515. Difficulty is that the other council, the brief is with the other council and he is out of station. Day after tomorrow? Day after tomorrow, Thursday. Friday, Lord. Thursday. On a request made by Sri U. Dotto, Learned Counsel for the petitioner, matter is adjourned to be listed on Thursday next. 19 matters, so we're not. Okay.
My lord, I have prior item number 4, my lord.
Yes.
My mother is, my lord, having some medical issues, my lord, for which, my lord, I need accommodation for this week only, my lord. Any day in the next week, my lord. She was hospitalized, in fact.
Why have you come to the court?
My lord, because again I have to go, my lord, to the...
Why have you come to the court? If she is
Make a
hospitalized, you need not come to the court. Somebody can mention in your behalf.
I understand, my lord. Since it's a...
No, this
2017
request
matter.
is, we find it difficult to accede.
2017 matter, that's why, my lord, I had to come, my lord.
No, somebody could have requested medical emergency. You come to the court to seek an adjournment.
My lord.
What is the practical? So you do the case, better to do the case.
I could not take preparation, my lord. Yesterday night only.
Oh, we will grant the adjournment, but
My lord.
is it practical?
No, my lord.
You can come to the court to make an adjournment, then you go back and say the mother is unwell. Mother is unwell, somebody, your friend could have, we could have accommodated. Have you ever declined accommodation on medical grounds? A prayer for adjournment has been made by Sri Jed Hamad, Learned Counsel for the petitioner on medical grounds. Para, considering the above, as well as the fact that the matter is pending since 2017, a slight accommodation is granted with directing listing of this matter on Monday.
Next Monday.
Monday.
Yes.
25th.
My lord.
25.
My lord. Deeply pushed.
Yes.
May it be please, your lordship. Lordship, I beg to mention for listing for next week, lordship.
Listing of what matter?
Foreigners matter, lordship.
Matter of which year?
2024, lordship.
24. What is the stage of the matter?
Better notice was issued. I think better was fixed for consideration of interim order last
Interim.
occasion.
Okay, next
Yes,
Wednesday. Next Wednesday.
Yes.
Not tomorrow, next Wednesday. I didn't want. Awesome.
May it please the lordship. Matter was heard on the other day.
We had completed the hearing, I think.
My lord, I have not completed, almost completed.
Almost completed.
My lord, I have prepared written argument. My lord, what I have made submission in the...
Why was it
Orally.
adjourned? Why was it adjourned?
My lord, my friend...
Paucity of time, lordship.
No. What was the stage?
Lordships.
Because our notes say that almost hearing has been completed.
His part has completed.
Not
lordship.
completed, my lord. Almost completed because of paucity of time, matter was adjourned.
Is it?
And my lord, here in this case, your lordship is to make inquiry about the Kabura certificate. Kabura certificate I have not annexed in the writ petition, but it is available in the record at page 52.
Page 52.
Yes, my lord.
Yes.
My lord, the evidence of the Gavura has been discarded only because the Gavura unable to say the name of grandmother. That means mother of the Babu Khan. Lordship may kindly have a look at the page 63, the evidence of the Gavura.
63.
63. In the read petition. My lord, his name is Abdul Karim Khan, aged about 88 years. My lord, senior most persons of the
He was marked as DW.
DW
4.
DW4, I think.
4.
My lord. Yes, DW4.
Please read.
My lord, I, on receipt of the summons from this tribunal, I have appeared to depose on behalf of Baila Khatun. Exhibit A is the certificate dated 10/5/2017 issued by me, and Exhibit E1 is my signature in this said certificate. Exhibit H is my identity card issued by the circle officer of the Sangha Revenue Circle. I know Baila Khatun and he is the daughter of Babu Khan. Baila Khatun was married with Manik Khan of village Suripur, and she is presently residing with her husband at village Guma. Baila was born in village Tarabari. Baila Khatun is residing in our village, and I am the Gavura of the said village. My lord, in cross, this certificate is a residential certificate. I have not read and aware of the executive instruction of Part 8, Chapter 8 of the Assam Land Revenue Regulation, 1886. I do not know the name of the mother of Babu Khan. This was the point taken by the tribunal.
Thereafter, second line.
I do not know the
Lineage.
of Baila Khatun. I have issued the certificate as a Gavura of the said village. I do not maintain the public record. My lord, Gavura may not know every details of a family, but he clearly deposed that he knows the father of the proceedee and the proceedee. And the proceedee is the resident, is born and brought up in the village of which he is a Gavura, 88 years of old person, my lord. Most senior citizen of the locality. Last year, this man died, my lord. Huh? My lord, this evidence in an elderly person has been clearly, convincingly deposed. Only he failed to say the grandmother's name of that too, my lord, a female name, my lord. Female name normally in the movement and
What about contemporaneous records? Certificate, how is it linked with a contemporaneous record? He does not maintain public records.
He is from personal knowledge. He is from personal
You know
knowledge.
the law, Mr. Sigdar. You know the law.
Personal knowledge,
You
my
know
lord.
the law. Can you say anything against the law?
If his evidence statement inspire confidence, that's sufficient.
Okay, that we will consider.
And what he has stated that she has stated that Babu Khan, his father's correct name is Babu Khan. And somewhere in the 66, 70 brutalist written as Bandhu Khan, Babu
Where?
My lord, that has been explained in the WS.
No, not the Gauhati, the proceeding has status.
Yes.
Yes, that we have seen. That we have seen.
So, and 61 brutalist, his father's name is written as Babu Khan. That has been, that brutalist we have annexed in the writ petition as a matter of explanation. And my submission basically was on the maintenance of the proceeding, and because the notice indicates the charge in between 66 to 71. There is no word suspecting to be foreigners of post 71. So declaration again as a post 71 is traveling beyond the charge by the tribunal. That cannot be. And the LBO report signify no charge, no materials. Entire LBO report is totally blank, and that has been also content that there was no fair investigation. So the LBO report and the reference cognizance, everything is um, uh, against the principle laid down by this whole court in the full bench judgment. And
Santosh Das. Santosh Das. also.
Santosh Das, that is cannot be charged.
Streams,
Tribunal
yeah.
cannot travel beyond the charge.
Cannot jump the streams.
Yes. Whatever indicated in the charge, in the notice, that beyond that it cannot jump. That was the principle. And LBO report, since LBO report cannot signify any charge. So, in the light of the full bench decision, in the light of the principle laid down in in Lal Babu Hussain case, this holding him as suspecting him a foreigner is principles, violation of principles of national justice, and it's a mechanical reference. And we have relied upon this case law of Rafika Bibi, Lal Babu Hussain, as well as Amina Khatun. So these are my.
What is the Amina?
Amina Khatun also said that when the LBO report is blank.
Amina is citation?
Citation I have mentioned in my written argument.
Okay.
Number 10, 2022 4 GLT 102.
Okay, it's
Yes, both copy you have. So.
Okay.
And when the LBO report is blank, that means there was no fair investigation. It was a mechanical reference. It cannot be sustainable. That was the principle laid down. So these are my short and submission.
Lal Babu is what paragraph?
My lord, paragraph 6 and 13 sub 13(4). Paragraph 6 and 13 within bracket 4.
And Rafika Bibi? Rafika Bibi paragraph?
Rafika Bibi, my lord, Rafika Bibi, there are several paragraphs. Rafika Bibi, this one, Rafika Bibi too. Sorry, my lord, I have not mentioned the case of Rafika Bibi. I may be allowed to mention the Rafika Bibi.
We have noted.
We have the case law, my lord.
Give the paragraph, if you can give the paragraph number.
Copy of my lord.
Rafika, you had mentioned on your last.
Yes, my lord. In a written argument, we have mentioned it.
No, even in your last.
Yes, my lord.
Argument.
Paragraph 31 and 32. My lord, I have a copy, my lord.
We have copies.
My lord.
We have copies. You just give the paragraphs 31 and
31, 32 and 33 also.
okay. Mr.
Yes, Lordship. Lordship, on earlier occasion, I have submitted Lordship in respect of Lordship that wrong mentioning of the string of foreigners in the notice, contrary to the reference, would not vitiate the ultimate opinion that proceeding is a foreigner of post 71 stream, Lordship. That was I have cited 2017 2 GLT.
You had cited Ananda Ghosh.
Yes, Lordship.
Is that a
Yes.
contradictory, I mean, is it conflicting
No,
on the basic principle that the stream
no,
cannot
no,
be
Lordship.
jumped?
No. Sontus thus is in respect of reference, Lordship.
Hmm.
It is in respect of notice. And
Notice.
Here, Lordship, reference is totally different, Lordship.
Your references with regard
Different,
to
Lordship.
71.
Yes, Lordship. Notice is different, reference is different, Lordship.
Hmm.
Sontus thus is in respect of reference, Lordship.
Okay. And this is with regard to notice.
Notice. 2017 2 GLT 996. Then Lordship, in respect of grounds also, my learned senior colleague has submitted, Lordship. So grounds, in Dukiali's case, what proposition was made that Lordship grounds may be mentioned in the notice itself, need not be elaborated and furnished separately. So
That you had submitted last
yes,
time.
yes, Lordship.
Dukiali 3805,
Yes, Lordship. And
8/3/2018.
yes, Lordship.
Well-
And after that, Lordship,
Anything new you have to submit, please do.
interesting and Lordship, what the Amina Khatun's case has been stated in this case, Lordship, on earlier occasion, I have submitted 2025 to GLT 1058. Sukurjan Nesa, where Amina Khatun was distinguished, Lordship.
This is 2017 2 GLT 996, Amina Khatun.
Yes, Lordship. That was para 20, Lordship, because stated, Lordship. However, in the case of Amina Khatun Supra, which was decided on 28/4/2022, the reference was made by the Superintendent of Police Border based on LVO by the year, but when the said repetition was being heard and decided by coordinate bench, it appears that the previous decision of the learned single judge of this court in the case of Samuddin versus Union of India as affirmed by the division bench of this court in the case of Samuddin in writ appeal number so and so were not brought to the notice of this court, Lordship. Therefore, under such circumstances, the court is of the considered opinion that under the well-settled principles of stare decisis, the decision in the case of Amina Khatun Supra would be per inquiriam. Accordingly, decision rendered in the case of Amina Khatun will also not be of any help to the petitioner. So, Lordship, on merit, Lordship, I am now submitting, Lordship, 1966.
Just a minute. (1966).
1966 voter list, Lordship, to 27th page number. It is of Khelli Reserve, Lordship.
Page 20.
27.
27.
Where projected parents' names appeared, Lordship. And then 1970, Lordship. Almost same, Lordship, same voter list, and discrepancy arises after 1970, Lordship.
From 70, next one is 1989.
1989. Here is a huge gap, Lordship, in between 1970 to 1989, Lordship, and WS is totally blank, Lordship, in respect of her father's. When her father expired, her mother expired, Lordship. Only simple statement is made in the WS that, Lordship, that the father's name of the second party, Babu Khan, alien so and so, and that my father and mother is already expired. Only that statement is there. When expired, Lordship, that was not mentioned, Lordship. So, Lordship, this is a huge gap of 19 years, Lordship. It was unexplained by the proceeding, Lordship. Then, Lordship, 1989 voter list is of different village, Lordship. where Proceedings name first time appeared at the age of 39 years. Prior to that, Lordship, Proceedings name is not appearing in the voter list, Lordship.
That is the voter list of
1989, page 31. At the age of, and connected person is one Manik, not Badu Khan or Bandu Khan, Lordship. Whereas, Lordship, proceeding, if we calculate the age made in the affidavit, Lordship, proceeding sometimes born in the year of 1957, and he availed his first voting right in the year of 1978. But till 1989, Lordship, there is not a single voter list has been placed by the proceeding. After that, after 1989, Lordship, 1997 voter list, here projected mother's name appeared, Lordship. But village is different and name is also connected person's name is also different. Babu Khan, not Bandu Khan, Lordship. And Lordship, this Babu Khan and Bandu Khan mentioned in the 1966 voter list is not same in one person, and proceedings totally failed to prove that, Lordship, these two persons are same in one person, Lordship. So, Lordship, now I only link between the proceeding and his father is now Gaubras certificate, Lordship. Lordship has already pointed out the Lordship evidence already. Lordship has noticed the evidence, Lordship. I have issued this certificate as a Gaubra of said village, last part, Lordship, and I do not maintain public record. I said, I do not the name of the mother of Babu Khan. I do not know the lineage of Bailia Khatun. Whereas this person at the time of deposition, he was aged about 88 years. Since 1930, she is existing in that village, but he don't know the lineage of this said Baila Khatun, Lordship. Baila Khatun. So, Lordship, and I do not maintain any public record. So, Lordship, Gaubra certificate on the basis of personal knowledge is not enough, Lordship. There is a settled law, Lordship. Lordship, I want to rely on Romila Khatun's case, Lordship. It is a reported case. (2018) 4 GLT 373. And connected WPC number is 3807 of 2016.
of 16.
3807 of 2016. And reported case is 2018 4 GLT 373. So para 22, Lordship, it was paragraph number was not given here, Lordship, but I marked it as para 22. It is tried that documentary evidence would have to be proved on the basis of the record, and the contemporaneous record must substantiate and prove the contents of the document. Proof of document is one thing and proof of content is another. Not only the document would have to be proved, but its contents would also have to be proved. That apart, the truthfulness of the contents of the document would also have to be established from the record. A document or the contents of the document cannot be proved on the basis of personal knowledge. So many settled laws are there, Lordship, in respect of this proposition, Lordship. After that, Lordship, one land document was annexed, Lordship, of village Tarabari, and where Phaila Khatun's names has been appeared, Lordship, at serial number 10. And this is not exhibited document, Lordship. Apart from that, Lordship, by showing this document, proceeding could not able to ascertain that how this land was acquired, Lordship, and by the original Patladar, Lordship. And it is a mutation order of 2018. Although in the order it was written that, Lordship, by way of উত্তরাধিকারী দখল সূত্রে, but from when they have acquired this land, that was not mentioned here, Lordship. So I think, Lordship, this document will not help the petitioner to establish his link.
It was not proved.
Not proved and not exhibited also, Lordship. And Lordship, it is again of village Tarabari. Lordship, Lordship, if Gabra's document evidence goes, Lordship, I think, Lordship, there will be nothing, Lordship, to prove his citizenship. Lordship, that's all, Lordship. And Lordship, অকল দুজনে সাক্ষী দিছে ন? অকল দুটাই সাক্ষী দিছে?
দুই ভাই সাক্ষী দিছে। দুই ভাই সাক্ষী দিছে নেকি? DW2 DW3 I got interested necessarily discard করিস।
Lordship, although another two witness is here, Lordship, but in pleadings, Lordship, there is nothing mentioned about the brother of the proceeding, Lordship. Lordship, in this respect, Lordship, I want to rely on Lordship. Mumin Ali's case, Lordship, which is reported case. variance between pleadings and proof is not permissible, Lordship. Proposition is that, Lordship.
Moin Ali citation.
2017 2 GLT 1076.
Paragraph.
Lordship. Paragraph 12, Lordship. After that 13, after that 17, Lordship. This written statement of the petitioner was wholly inadequate and did not disclose any material facts. As noticed above, it was allegation of the state that the petitioner was a foreigner. Therefore, as per mandate of Section 9 of the Foreigners Act 1946, it was the bounden duty of the petitioner to have disclosed all the material facts which are specifically within his knowledge in the written statement, but he did not do so. Petitioner neither mentioned his date of birth nor his age. He was silent regarding the name of his mother and identity of his grandparents, both paternal and maternal. He did not mention anything about his brothers and sisters or about his marital status. On the basis of such written statement, it cannot be said that the petitioner had stated anything substantial to show that he was not a foreigner but a citizen of India. It is a settled proposition of law that where a party fails to set up a case in his pleadings, he would be debarred from adducing evidence in support at this stage of trial. As a matter of principle, variance between pleadings and proof is not permissible. Then para 17. Reverting back to the written statement, it has already been noticed that there was not a whisper by the petitioner that he had any brothers or sister, not to speak of disclosing their names and other particulars. Therefore, the sudden appearance of Umar Ali in the witness box as brother of the petitioner has to be looked with suspicion, and this suspicion is further forfeited by the fact that in the 1997
Further for fortified,
So and
not
so.
forfeited.
Forty-five.
Fortified.
Oh, fortified, yes. Fortified by the fact that in the 1997 voter list, Exhibit 3, name of Umar Ali did not appear along with the petitioner. So here the same thing, Lordship. So, Lordship, there is no infirmity in the opinion passed by the learned tribunal, Lordship.
Okay.
So, Lordship, opinion may not be disturbed, Lordship.
Is better. Here, Siddhar. Then all the names. Here is concluded. Just want to say.
My lord, may I say a few words, my lord?
Yes.
My lord, here in this case, the petitioner, although in WS did not mention his brother's name, but in cross-examination, he has mentioned his brother's name. So, my lord, it is not the law that every detail should be in the WS, and there is, as per the law, my lord, there is no mandatory requirement of filing of WS as per clause 3 of the Foreigners Tribunal order. And Supreme Court in the Sarvanada Sunwal case, paragraph 26, emphasized only to adduce evidence, not to file any WS. If otherwise he is mentioning everything, then for not mentioning in the WS, the evidence cannot go. My lord, that should not be the spirit. And law does not say to file mandatory requirement of the filing of WS. The clause 3 says that there shall be an opportunity of filing a representation. So representation may be in details, may not be in details, maybe a shortcut. For that, my
No,
lord,
we are not on the nomenclature, Mr. Siddhar. We are not on the nomenclature, whether you call it an application or representation or written statement. You have to plead your defense. that I am not a foreigner for these reasons. If that has been held to be the basic document. You have said Sarvanda Sunal has not said. Sarvanda Sunal has in fact said.
Yes.
It's a basic document.
Yes.
You may call it a,
Emphasize only evidence, not
no,
filing
no,
WS.
no. It may be a representation. It
I may
be a-
disclose everything in my evidence. That cannot be discarded.
Let us see what is page paragraph 26 of Sarvananda.
No.
Please read.
There is good and sound reason for placing the burden of proof upon the person concerned who asserts to be a citizen of a particular country. In order to establish one's citizenship normally, he may be required to give evidence of his date of birth, place of birth, name of his parents, their place of birth, and citizenship. Sometimes the place of birth of his grandparents may also be relevant, like under Section 6A1B of the Citizenship Act. All these facts would be necessarily be within the personal knowledge of the person concerned and not the authorities of the state. After he has given evidence on these points, the state authorities can
2006
verify the facts
542.
and can then lead evidence
If
in
necessary.
rebuttal if
Okay,
necessary.
we'll consider.
If state authorities
Okay, next.
17. Yes. So my submission, my lord, are basically on the maintainability. There is changing the charge, overriding the charge, the tribunal cannot arrive at a conclusion. That is my submission. At best, he may be declared as a foreigner of in between 66 to 71. Not a foreigner of post 71.
Okay, let's see. Yes, next.
My lord, I have two other matters, my lord. I may be, my lord, allowed to not to take matter at this today, my lord. Item 5 and 13 may be adjourned for today, my lord.
5 we are ready. 5 will not adjourn. 13
My lord,
will-
I have some personal difficulty, my lord. I cannot.
17 matters.
I have also not. If the brief is not with me, my lord. Net Thursday, my lord. Thursday, my lord.
17 matter Thursday.
Yes, my lord. Thursday.
5 will, and 13 will not passing any order. Let 13 reach, then we'll see. 5 will have it on Thursday. 5, huh? A request for adjournment has been made by Sri A.R. Sigdar, Learned Counsel for the petitioner. Para. However, considering that this matter is pending since the year 2017, while adjournment has been declined, a slight accommodation till Thursday is granted. Full stop. Please list on Thursday. Please give the
Right.
date. Item 2. Insurance matter.
Insurance. My claim was repudiated by the insurance company. I filed the appeal before the ombudsman, and ombudsman also rejected my prayer. Subsequently, I came before this honorable court, my lord, and the learned single judge also dismissed my writ petition. Now, my lord, I am taking to your receipt to the impugned judgment and
It's
order
for
of
admission.
admission.
We can admit for hearing. If you are agreeing.
Let it-
But letter, we have to be prima facie satisfied with the, what is the illegality in the judgment?
Illegality.
What is the prima facie illegality? To admit it there, you have to make out a case of
Because
illegality.
in this particular case, what has happened? That the learned single judge has come to the conclusion,
Insurance was for what?
insurance of a business place, my lord.
Shop.
That is so.
Shop.
soap. And the claim is admitted, but it was rejected on the ground that it was not a soap, but it was a godown. That was only the ground. And secondly, on the ground that I did not obtain the trade license. At the time of occurrence, there was no trade license. But in fact, I applied beforehand and subsequently it was given to me also. Apart from it, these provisions contain section 180 of the Municipal Corporation Act regarding the licenses concerned by law. Those are only regulatory. Those provisions do not ban that I cannot carry on the business at all without obtaining the license.
But these would be the yardsticks which an insurance company would like to get itself verified when a claim is made. You may make a contention that license per se is not mandatory to run a business. It's a regulatory condition. But how do the insurance company verify a claim? First, objective verification. Do you have a license? You do not have a license. Then the second part is subjective, whether it's a godown or a shop. They have come to a subjective satisfaction that it's not a shop but a godown.
Godown.
And the insurance is not for a godown but for a shop. And therefore it's been repudiated.
No, that is the thing. For that one, my lord, may I take your lordship to the impugned order at page 128. The relevant portion is page 128, my lord. 128, that is the operative part, my lord. Para 28. Have you got it, my lord?
Para
28, page
Page-
128.
128.
128. Para 28. Even if it is assumed.
Just a minute, please. Yes.
Even if it is assumed that the contents of Mr. Bhatti, that learned ombudsman, has unduly placed reliance on the photos produced by surveyor to suggest the premises in question was used as the godown. In absence of any material from the claimant himself, that it was a soap and he has trade license for running the soap, this court has such a judicial cannot interfere with the impugned order. In this particular case, my lord, first of all, I produced the license, though it was given subsequently, and for that particular purpose. And secondly, my lord, the photos which have been relied upon, they were taken post occurrence, not prior to occurrence that it was a soap or godown. Post occurrence of the incidents.
It was gutted or it was stolen? What had happened? Fire.
No, it's
No,
water
immediate
inundation.
flood. The claim is not disputed. The loss is not disputed. So this finding is purpose finding, my lord. Because first of all, the learned signatures has relied upon that the photo shows that it was a godown. Those were the post occurrence. So that they does not, because your lordship is well aware regarding the provisions of the Evidence Act, section 56, it says that judicial notice some facts are to be taken. In this particular case, if the judicial notice is taken, in that case it cannot be assumed that it was soap after occurrence. The photos, I would show your lordship from the photos that it cannot be assumed that it was only the godown. Secondly, first of all, your lordship will come
What
that
do you say, Mr. Goswami?
No, see, it's not just the trade license. That was only one part of it. The major observation of the para 29 after 28, 20 and 30 make it clear. The Honorable Ombudsman as well as the Honorable Single Judge Lordship had relied on this documentary, survey report, investigation report to come to this conclusion Trade license is just only one part of it. Now, sir, moreover, Lordship, his own documents, Lordship, he had insured 3 places. All were insured as shops. His accounts, Lordship, very clearly so. It is observed by the Honorable Single Judge also. And no transaction takes place from this particular ground. Transactions take from the shops in Fancy Bazaar. And goods are delivered from this place, indicating it is a warehouse. In his account, Lordship, page 101, Lordship, and 99 of the year, Lordship. Very clearly seen. He had in other places, he pays a rent of so many thousands. In this case, rent was 7,70,000 minutes for a considering the space. He describes this as a godown in his accounts. In his claim intimation letter, he says that my godown has been inundated by
My
flood.
lord,
Let us see the policy.
Is it?
Policy, where is the policy?
policy or lordship will find at page
So here is additional, etc. We honor it, honor us.
us.
It is the principle. You. We got this.
He- ये देखो ना. Yes, at page 51.
50,
51.
51. Where is the indemnity? Which part deals with the aspect of indemnity? What are insured by this?
Clothes. Your lordship will see nature of business rate clothes. And those were,
Section-wise premium details.
yes,
First is not opted. Second, fire and allied perils contains excluding money and valuables.
Also, that allied perils also include flood
Okay,
or
Yes.
natural perils.
okay.
that
Flood is-
claim on the basis of the flood is not disputed.
No, that is not in dispute whether
Yeah,
you get a
that is
claim.
not
The
disputed.
only thing is that it is a shopkeeper's insurance.
Yes.
Yes.
Shopkeeper's insurance.
Also
Yes.
may come to, just
Where is the claim?
it's just, also may come to
No,
page
which
101.
page is the claim?
Claim, my lord, I lost on at page 68. Sorry,
64. 64, 63, 64. Claim intimation letter in 64, page 60.
it was filed on 207/22, 57.
Described as godown.
Yes, my lord, by at page 68, my lord.
Lockdown.
Uh-huh. 60.
Now go down.
63, my lord,
Page
page
63.
63.
Page 63. 63.
My lord, only for that reason that I have mentioned in go down. It doesn't mean if I can explain it, that it was not the go down, but it was the business place. In that case, I am entitled to.
The certified
And
accounts is page
assuming
101.
Please, assuming for the sake of the argument, my lord, that it was a go down, my lord.
Mhm.
Even though it is not the case so far the bank is, insurance company is concerned, my lord, that it is the material non-disclosure of effect. And they would not have issued the insurance policy had it been disclosed by me that it was a go down.
The
all
policy,
these-
policy scheme is different from for go down and shop.
They are different
No,
policies.
there is no difference at all, my lord.
There's no
He could
substantial.
not make out any difference, my lord, and let him say about it. And even though, my lord, so far the soap is concerned, the premium is much more than the go down insurance.
Mm.
That is specifically I have taken in my details. Either your lordship may admit it or hear it. Entirely, I am ready to argue.
No, Mr. Goswami, is it your case that a policy for shop and policy for go down are distinct and different
Policies.
policies?
With different stipulations.
Shopkeepers' policy will not cover a go down.
Mutually exclusive in a way.
Not say
Is it like that?
shops, they have a go down. When it is annexed to it. They keep it in the backside of it, they are part of it, it's annexed to it. But go down in a different entity altogether. One is in Kalapahar area, one is in, this shop is in Fancy Bazaar. Lordship may come to page 101, Lordship.
My lord, for that
I
particular
just-
purpose, may I take your
Just a minute.
101
We found.
of my affidavit, Lordship. Next is certified accounts,
10.
This,
101.
Mr. Both of you, see page 64, you had made a claim for damage suffered by waterlogging in your godown. Where is the address? Where is this godown situated?
at Kalapar.
Alapahar. Let us see the policy. It was for which area?
It is Kalapar, my lord. That is
Address AK Azad Road, Kalapahar. Campus of Brahmaputra Jute Mills. City man.
53 pages.
May come to page 101, that's his own certified accounts, says it is a go down.
How it can be.
Maybe one limitation, maybe a typographical mistake or slip of pen. But certified account saying the same, page
In-
101. It describes rent paid for three premises. Neha Jain, 144, SL Jain, 36,000 is annual. And go down rent is
Page 101, which paragraph?
101, not see, it says account, certified accounts.
Which subparagraph?
Schedule 3 rent.
It's not 101 then.
Go down range. Doesn't mean that
Page
page 101.
101 is internal page 71.
102. 101, my lord.
101 is a part of
Reply, their reply to the writ petition. my lord.
Another thing is that this policy schedule for shopkeepers insurance. The policy mentions shopkeepers insurance.
Yes.
The one question that comes to my
Shopkeepers
mind is
means,
that
this
is there any
shopkeeper-
specific
it is not
policy
in
for
relation
godown?
to soap. It may also include the godown.
No, that's why I'm asking. Is there any separate policy for godown or this covers?
Go down is a
No,
separate policy.
because regarding that position, he may clarify it, but
Yes.
in my
It's the same.
submission, it is one and same.
Yes.
It is shopkeepers.
That covers go down according to you.
Yes.
But 101 you're trying to show, where is 10? 10?
101 of
They
their
have the same thing.
No,
affidavit in
That's
opposition.
my affidavit.
95 your affidavit in opposition starts, 95. Page 95 your affidavit in opposition starts.
Yes, Lord, sir.
It
Then-
starts from 65.
No, 95.
There's some numbering.
There might be some.
I think he has given me the. আপনার number একই আছে।
Yes. Go down rent. That doesn't mean, my lord, this rent has been paid only for this one. I may have somewhere else other go down.
Lordship, Lordship, there's an
May-
accounts, Lordship, annexed.
Annex 3, it starts from 99. And
You get, you page, which page, Mr. Goswami?
affidavit in opposition, my lord.
Lordship,
Affidavit in opposition ends at page 110.
190.
Yes,
110 is the last page.
yes. Thereafter,
No, 102. Page 101.
101.
101.
101.
101 we have seen.
Say annex to and forming part of the profit and loss account for the year ending so and so.
There you
Schedule three.
will find the go
10.
down rent.
101 are part of paragraph 3 and paragraph 4.
The number is.
May-
Can you say this?
may-
No, no. How you have to need to present it properly. This is your presentation. Single judge or various other. Single judge opinion details. No, no, no. This one is another. Single judge is really not. This was for.
Affidavit in opposition. No, read petition, no, affidavit in opposition. Yes.
That's
petition
what
affidavit.
given this petition.
It could see it as a no, no, in the writ appeal, we are not in the writ petition.
Yes, he is referring the
I'm not very dear, because it's.
affidavit in opposition in filed in this petition.
That is a part of the writ appeal. Everything
Yes.
has been enclosed
Go down rent.
in the writ appeal. Kali, yaar dekho na konto page. Show us the page in this court file.
Oh,
Court calendar.
yeah. তুমি কোনটো পেজে ওলাই দিলা? কি হয়েছিল? রিট পিটিশন হ্যাঁ क्या
Mr. Goswami, you also have a look. Where is 101 is not matching.
ये क्या है? रीट अपील My lord, it is writ appeal. Your
We are,
lordship
we
will
are,
go to
we are going in a writ appeal.
writ appeal, but he is referring the opposition in where I have not annexed the annexures. In
You
writ
should
appeal.
do the
That's
entire
why-
thing. Why
that's
have you
why-
not given?
That's why, my lord, the record has been called for. And
See, you are mandated by law to annex everything in a writ appeal. Why haven't you annexed everything? We are not going to see the record of writ petition. Writ appeal has to be a consolidated thing.
Yes, my lord, those has been annexed as the annexure B. Oh, sorry.
But Mr. Goswami, where is your stand that there can be a separate policy for a godown? Have you stated that?
There's an additional affidavit.
That is a crucial question, I think. If there is a separate policy, then that is a factor in your favor.
Stated in my affidavit. of
Yeah.
opinion.
What have you stated?
That is-
No.
that was given.
Yeah.
In that case, Lordship, this has to be looked into my affidavit in opposition because that was, the judgment is based on my affidavit in opposition. So,
Where have you stated in your affidavit of motion that you can have a separate policy for a godown? And the shopkeeper's policy is confined only to a shop.
That, Lordship may just, I have mentioned this in para 16, Lordship. That with regard to the statements made in paragraph 19 of writ petition, para 16 of my affidavit.
Yes, please read.
Respondent said that the occupancy of the premises is an important material fact.
Page.
It will get taken. Area of in opposition.
Affidavit.
In fact, differential system of premium ratings and underwriting considerations, warranties and terms and conditions are on the basis of categorization of risk only. When you say that they tantamount to the same thing. No, Lordship, in godowns, there are several categories, like godowns for hazardous materials,
Mhm.
godowns for less hazardous materials, godowns for explosive. So
Yeah.
godowns are categorized according to their occupancy. For with what kind of materials has it been occupied with?
Risk factor.
And how is it separated? There are a lot of other factors. It's not just a premium alone. The stipulations that go with it, that this will not be mixed. There are various stipulations in godowns. That kerosene oil lamps should not be used.
Mhm.
That might say there's some here, and then so much of hazardous material like crackers, etc., would not be stored in a godown. There are various stipulations attached to it. Now that will be a big yellow. But I have taken this, the reason for reference they claim up on the basis of sound, that's, but I have stated this. It's warranties and terms and conditions are on the basis of categorization of risk. The risk for explosive materials like crackers, etc., would be different. Highest rate would be applicable. Then lesser hazardous, more hazardous. These are the categories. So shopkeepers are universal. The same rate would apply to a shop in Nunmati area and Fancy Bazaar area.
No.
Shopkeepers' rates are universal, uniform. The godown rates are different depending on their occupancy. And also that page, if Lordship will come to my opinion of position, Lordship may find in that accounts part, Lordship, and number would be different, Lordship. But if accounts, so it's a certified accounts, he has given it to us. I had given it to the Lordship. It shows that he had altogether paid 9,53,253. Now he cannot say there are different premises. It has given account of just 3 premises.
Yeah.
Total rent he pays during the year. He cannot bring in the 4th godown. The account says so. In one godown, Neha Jain, it has to be for a shop in Fancy Bazaar, 1,44,000. Under one, probably a lesser, smaller shop,
One
SL
shop.
Jain, 36,000. And godown rent, he specifies for one, 7,73,250. Bigger size, bigger space, Lordship, and the amount is also big. And he describes it. Now there's in another place, there's under reference, godown rent. So it just can be mere mistake, typographical error, or slip of hand. It was intended to be a godown. It was used as a godown. The photographs taken by the surveyor show it, Lordship. Lordship, photographs are also there in my affidavit, in his writ petition. The photographs doesn't look like a godown at all, Lordship. Even in my age there. Shop at all. It's just the hallmarks of a godown, Lordship. In the same affidavit.
Page?
In the same, Lordship, prior to just before that accounts part. In my is the page 86, 87. Yeah.
Mr. Bhatti has not enclosed everything.
These photographs are there. It was there.
So in the writ proceeding, might have been there. In the appeal,
In the appeal is not there.
whoever presents the appeal is required to.
I have not read it.
Give a direction for bringing this on record.
What is the page in the writ petition?
Read petition,
Petitioner-
that is their affidavit opposition. It is such page from 65.
Oh. Oh, it will- The shop now go down. Yeah.
It's inside a jute mill
No.
campus.
This is a good now. It is covered.
Inside a jute mill campus, now this nothing doesn't look like no shop would be there inside a jute mill campus.
So would it be correct to say that the godown is covered by a shopkeeper's policy? However, in making a shopkeeper's policy for godown, there has to be separate endorsements, something like that? Is it something like
Godown
that?
is a separate policy, or they are
Separate
categorized.
policy altogether.
There is a various types of godowns.
Separate policy altogether.
Separate policy with various separate terms and conditions, stipulations.
Then it will be different.
Plus, in these photographs also, there is no shop is. It just gives
These
a
are
general
the
impression that this is look like a
Post occurrence.
post occurrence, obviously. Lordship may come to also
Just a
single
minute.
court lordship, honorable single court lordship.
My lord,
Yes,
if
so
your
we
lordship
can
is going to
discuss
hear
on
the entire matter, in that case, may I start? My lord?
No, there is
Or-
nothing to be aggrieved or differ with the opinion of the honorable single judge.
My lord, I would so. In that case, let me argue the case, my lord, and I have. I
Argue
will
to the-
satisfy. Yes,
argue
yes,
it.
my lord. First of all, my lord, I am taking to your lordship to the operative part of the order, my lord.
Hmm.
At page 28, 29, and 30.
Paragraph?
Paragraph 28. It starts from paragraph 28.
In the rate appeal,
Rate appeal. At page 128. May I read it, my lord?
Yes.
Even if it is assumed that the contention of Mr. Bhatti that the learned ombudsman has unduly placed reliance on the photos produced by surveyor to suggest that the premises in question was used as a godown, in absence of any material from the claimant himself, that it was a shop and he has trade license for running such shop, this court in exercise of such a duties cannot interfere with the input awarded. Now, my lord, on this one, next one your lordship will find para 29. The reliance placed by ombudsman upon the survey report in a summary procedure like the present one, in absence of any cogent material being placed by the claimant, even prima facie creating a doubt upon such survey report or any challenge to such survey report before the ombudsman cannot be said to be perverse. Therefore, the argument advanced in this in the totality of the matter, the factual determination made by the ombudsman in impugned award, based on the material produced by the party, in considered opinion, this court cannot be fastened with an determination based on no evidence. That being the position, this court is not inclined to interfere with the impugned award passed by the learned ombudsman in exercise of his statutory jurisdiction. This is the finding. My lord, first I thought whether it was a go down or business place. I am taking to your lordship to now, apart from it, may I take your lordship to para 26 and 27
Of
of judgment.
judgment.
The learned insurance ombudsman in his award under challenge duly considered the contentions of the parties, including the survey report. The police and also heard the party. After consideration of the documents as well as the verbal submissions and perusal of the record, the claim was rejected primarily on the ground that the claimant was not having any trade license and he got trade license on 9/10/2020 after the law. The learned ombudsman also placed reliance on the report of the surveyor and accepted the same, and also considered that though the premises which was insured by the godown, however, policy was a shopkeeper's policy. Though Mr. Bhatti has said that in terms of section 1802, the trade license was subsequently obtained with effect, covering the period of incident and which is permissible under law. This court is not impressed with such an argument inasmuch as validity with respect to operation may have implication in a dispute under Gauhati Municipal Corporation Act, but cannot be asserted in a dispute like the present one, where admittedly the policy was the shopkeeper's policy. On the declaration of the petitioner himself, on the date of the claim, there was no license to run such a shop. Such license bears significance in the backdrop that the petitioner, in his intimation letter, described the premises as godown. Had there been a valid trade license of a shop on the date of incident and on the date of claim, this court could have accepted the argument of Mr. Bhatti that the description of premises in the intimation letter as a godown was a mistake. That is the thing. Now, first of all, I am taking to your lordship to the ombudsman order, my award, my lord, that your lordship will find at page 75 of my writ petition. Of my writ appeal.
Date,
Page 75. my lord.
date,
Uh,
what is the date? 23/2/21.
Date is, my lord.
23/2/21,
Yes, it is 23rd
75.
February 2020.
page 74.
Writ appeal.
23/2/21. Cluster third task.
Yes, I've seen. Yes, yes.
Directly, my lord, I am taking to your lordship to the operative part. That is at page 77. We have taken into consideration the facts and circumstances of the case from the documentary as well as verbal submission made by the complainant and representative of insurance company. We have also gone through the records. It is evident from the service report that at the time of the laws, the claimant was not having a trade license. They got the trade license from Gauhati Municipal on such and such. After the date, trade is a must for every type of business. So at the time of laws, their business was not legalized by the competent authority, though they have GST certificate where this premises is mentioned. Now, my lord, this is only on this ground that at the relevant time I had no trade license, valid trade license, and that was only the reason of rejection of it. And not any other point, my lord. Now, my lord, first of all, whether
Yes,
for this particular, first of all, I am taking to your lordship to registration certificate at page 48. Have you got it, my lord? Now, my lord, your lordship will see legal name Kailash Jain, Sri Kailash Treasurer, constitution. On next page, my lord, the address is given here. Allahabad Bank building. Now your lordship will see on next page.
Yes.
Next page, your lordship will see total number of additional places. I am giving more stress on the word, my lord, of business in the state. It is not the go down, my lord. Now, your lordship, see address number 1, Brahmaputra Jute Mills Private Limited, AK. This is the business place. So that it is not a go down. According to the trade license, which I owe, sorry, this GST registration, my lords, it was a business place. And so,
Mr. Bhatti, with all due respect, this is not the relevant document. We are not concerned with your registration. We are concerned with your policy. You may have business in a godown, you may have business
yes,
in a
my
shop.
lord.
That is not the question at all. Question is whether the policy was for a godown or for a shop. If you can make out that the policy was a
Yes.
wholesome policy
For
which
shop.
covers even the godown, then you are through.
Yes,
This
what
restriction
I
has
am
got
going to
nothing
show.
to do with the policy.
Now, your
Concerned
lordship,
with
the
the policy.
next thing, your lordship will see that at page 69, page 69,
669.
69,
Yes.
this is the letter which I have written to the GMC on 5/11/2019.
When was the incident?
Incident took place, my lord, on prior to 2/07/2022.
No, roundabout incident. It was during
Roundabout,
COVID.
my lord, during the flood period, and first claim
No,
was
during COVID. You said that during COVID you could not visit the godown and you had opened it, you found that the
yes,
flood water
during
there.
the
So what was the period?
yes, 2/07/2020 we made the complaint.
Huh?
We made our claim
No,
on
that we have seen.
2/07/2020.
27 to 2020.
2/07/22.
20th of July.
Yes, we made.
20th
And
of July.
prior to it, there was the flood, and on that particular day, we opened it and we got.
Claim made.
Yes. Now, my lord, your
What is
lordship,
page 69 you want to show us? What do you want to show us in page 69?
from this one, what I am going to show that I started the business and accordingly I applied for the permission from GMC. You are hereby requested to issue me a trade license for my business located in Campus Road in the name of Sri Kailash proprietor. The copy of the rent agreement that is enclosed here for prejudice. Please do the needful and this license was granted. Pursuant to this one, the license was granted on very next that is 9/10/2020 after occurrence. Now your lordship will see, so far this license is concerned.
It was granted after 1 year, almost.
Yes, almost 1 year. Now your lordship will see the very interesting thing below 2020-21. That is for that current month, current year, 31st such and such. On remark, your lordship will see penalty remark 2019-20 rupees such and such penalty, rupees total rupees such and such. So that it was regularized with effect from I made the application. Now, my lord, the question here So that it was the trade license of a soap. So this being the position, my lord, though it has been given the, but they realize the penalty. Now, my lord, I am going to show you, I am taking to your lordship to section 180 of the GMC Act, my lord. What it says, my lord? One minute, what I say. One eighty, my lord. May I read it, my lord?
Just a minute, just a minute. Page 180.
Page,
180.
this,
Page
page 80
of
of this page. Page 80, provision 180, section 180.
Page one,
it up.
Section 180. That deals with the trade license.
GMC.
This trade license was available at a time when the appeal was filed before the ombudsman. And this was produced, license. 180.
Yes.
May I read? Every person who exercises or carries in the city, either by himself or by an agent or representative, any of the professions, trades, and callings indicated in fourth schedule shall annually take out a license before the first day of April in each year or within 1 month of his taking up the profession, trade, or calling, as the case may be, and pay for the same such fee as mentioned in behalf in the schedule. Provided also that the grant of such license shall not be deemed to affect the liability of the licensee to take out a license under any other section of this Act. Provided also remit or refund any portion of fees for payable in respect of exercise or carrying on the business, professional trade, or calling, if he is satisfied that the professional trade or calling has not been exercised or carried on for more than 6 consecutive months, exempt a person who, in the opinion of Commissioner, is unable to pay the fee due for a license from liability to take out such license, or declare that he shall be entitled to take out a license in a lower class than under which he is chargeable according to the said statute. C. In any other case, exempt any person from liability to take out a license, or declare that any person shall be entitled to take out a license under a lower class than the who is reported, my lord. The commissioner may at any time grant a license for any previous year for which no license has been taken out on payment of fee which would have been payable thereof in the first instance. My lord, I have taken to your lordship through the license. They granted in respect of the previous year, 1920. It means it is a valid license. Now, my lord, these provisions are not the prohibitory that without opening the license I cannot carry on the business. It is only regulatory. These provisions are only regulatory, not prohibitory, my lord. No bar has been placed that I cannot in this particular case, I applied for the license prior to obtaining the insurance policy. And it was granted by the subsequent, because it was not in my hand to obtain immediately from the GMC, my lord. And accordingly, it was granted after expiry of the period with the penalty, which I paid, so that it was regularized with effect from 1st April 2019 to 31st March 2020. In support of this, my lord, whether these provisions are regulatory and whether it would invalidate my business can be said illegal. For that one, my lord, I am relying upon the judgment of the Honorable Supreme Court. My lord, reported in.
The learned single judge has said that for the purpose of not having the retrospective trade license, that could be acceptable for disputes with the GMC, but for the purpose of the insurance policy, that will not do. Whether that is
Not
correct.
only insurance,
That has to be
not
seen.
only that one, but also for others too. In that case, my lord, we cannot limit the scope of section 180.
Okay.
Now, my lord, in support of it, my lord, I am taking to your lordship to the judgment AIR 1971 SC page 246. I have the copies, my lord. The copies. I have the copies, my lord. My lord, paras 5, 10, and 30. 5, 10, and 30.
Five,
5, 10, and 30. May I read it, my lord? Para 5. The High Court held that permission under section A3C was a condition precedent to the shifting of the location of rice mill. And since the appellants did not obtain the previous permission to shift the mill, the order of the director was liable to be struck down as ultra-virus. In the view of this court, by the shifting of the appellant's rice mill, the respondent's business was directly affected, and they had a right to challenge the legality of the order. The High Court upheld the claim of the respondent on the sole ground that the order of the director was made in violation of the mandatory injunction of the rice mill industry regulations such and such, and it prejudicially affected the business of the respondents as rice millers. Now, my lord, para 10. The Director of Food and Civil Supplies sanctioned in exercise of the Power Certain Act, the location of rice mill of the appellants may be shifted. The High Court declared the order invalid on the ground that the previous sanction had not been obtained. The court observed that where an officer granting a license for passing an administrative order exceeds his powers and makes an order in violation of the provisions which clothes him with the power, his order is liable to be struck down. And since section 8C contemplated grant of permission for change of location before the plant and machinery was actually shifted to a new site, the Director of Supply had no power to grant permission after the money had been shifted. Now, my lord, section 30. The section 8C
8.3C.
is merely regulatory. It is not complied with, if it is not complied with, the appellants may probably be exposed to a penalty. but a competitor in the business cannot seek to prevent the appellants from exercising the right to carry on the business because of the default. I am skipping over it, my last 4 and 5 lines. The appellants complied with the statutory requirement to carry on the rice mill operation in the building on the new site, even assuming that no previous permission was obtained. The restaurant would have no locus. Right? That is a different thing, my lord. They are, in this particular case, my lord, too, the provisions contain section 180 are regulated. And there is no absolute, so far, my lord, that finding is concerned by the learned single judge is a perverse, my lord. So being the regulatory, my lord, it is not the case that I have not applied for it. Those documents were before the ombudsman and before the learned single judge, my lord. This license was before that. It was before the ombudsman and also before it, my lord. The second question, my lord, which relates to the survey report. Now, my lord, your lordship will come. First of all, the survey report, my lord, that your lordship will find I have not annexed with it, my lord. But may I refer the writ petition, my lord, their objection, my lord. They have annexed it, my lord. At page
Writ petition, which page number?
my lord, your lordship will find the survey report at page 81 of their affidavit.
Of the writ petition?
Yeah, writ petition of their affidavit in opposition.
In the writ appeal, which page?
Page, my lord, writ appeal, I have not.
Okay, we'll come back.
Much okay.
Please check the writ appeal file or the file. Connect the pages is difficult otherwise to follow. the file.
I'm going to give the trouble to go to the writ petition, my lord. Affidavit at page, survey report is at page 81, my lord. And my lord, I'm directly taking to your lordship. At page 83, my lord. Now, situation and orientation. The insured premises is situated at AK Azad Road, Kalapatar, campus of such and such, Assam. The premises is used as a godown workshop. That is the first remark, my lord. Now you will also will see the note vacant premises is Sony Steel Private Limited, NS Traders. And now you will also will see nature of the business from below to fourth column. Retail of mattress, fiber, tulsi clothes, coils, mesh, etc. from etc. Hello, what it indicates? Retail. From below to fourth. Nature of business. Have you got it, man?
Yes.
Retail of mattresses, fiber, tulla cloth, coir, mesh, homes, etc. If I am carrying on the retail business, my lord, retail, then there is no question that it was a go down.
But what about the situation and orientation?
Yeah, yes, only he has given.
The insured
Now-
premises
now-
is situated so and so.
Now on next page, my lord, I am making the position clear, my lord. Next one, my lord. Your lordship will see observation. Second paragraph of it. That is very important. Observation, second paragraph. The undersigned made an inquiry with neighbors of the insured godown to find out the cause of flood. Now, my lord, he has not made out any inquiry whether I am carrying on the business or not from there, or it is a business place or a godown. He has only made in relation to flood. Flood. It is revealed that due to continued heavy rainfall in Gauhati, the drains overflowed as a result. The water entered the Brahmaputra campus, and flooded many shops, godowns, creating considerable loss to the property. The flood water entered in the insured godown, affected damage. Now, my lord, next one. As stated above, admission of the claim. That is stated above, the loss was caused by the flood, which is an insured peril under the subject policy. Moreover, the incident occurred during currency of the policy, but the policy was taken as soap, but the risk is gone down. My lord, there are no finding at all given that it was a go down. Because neighbors were there, your lordship have already seen at top, there are various neighbors. He did not inquire from the neighbors that whether it was a soap room or a godown. There's no murmur at all. Merely he has opined. There's nothing to show.
No, Mr. Bhatti, you have to be very clear in one aspect. You have to be very clear in one aspect. Whether is it your case that irrespective of the premises being a godown or a shop, you are entitled to the claim. That is one. Or number two, is it your claim that there is a wrong finding to the fact that in spite of the premises being a shop, it has been treated to be a godown and illegally repudiated? Which is your case?
In my case, it was a business place. And I have shown your lordship from my.
No, that is not an answer. Either you have to say that it is a shop, they have come to a wrong finding, it's a godown and wrongly terminated. That is one.
Yes.
That we can proceed on that. The other is that it is a godown, but the policy also covers
Go down.
a godown.
Yes, my lord.
Which is your case?
On both I will come. on both the one. First of all, I am showing your lordship through my trade license, through my GST certificate, etc., that it was a business place. Now, my lord, your lordship will see.
It is a godown.
Secondly, my lord, assuming for the sake of the argument that it was not a business, it was not a shop,
Shop.
but even a godown. Even though, Lord, my lord, where is the finding that I suppress the material fact? And had I disclosed that it was a godown, the insurance company would not have issued the insurance policy. Would not have issued the insurance policy. In respect of this, there are 16 of my writ petition, my lord. I am taking, my lord, certain paragraphs of my writ petition, my lord. That is at page 34, para 14, para 16, 17, 34. Sorry, my writ petition. Writ petition. एक मिनट, एक मिनट.
Mr. Goswami, have you sit? Will come please.
There are 34. There is 34. of my writ appeal.
You are taking us to the writ petition, you can mention. Refer to the petition, writ petition, no problem.
That is page 13, my lord.
13.
Para 14, my lord. Para 14, 16, 17, 19, and 20. That the petitioner begs to state and contain that the learned ombudsman rejected the claim of the petitioner on the ground that at the time of close the petitioner was not having a trade license, which is a must, and secondly, on the basis of finding of the report of the surveyor, the premises was used as a godown. In the instant case, the petitioner applied for trade license as per the business premises in question of such and such, and the trade license was granted up to such and such. While granting the trade license, the Gauhati Municipal Court also realized not only the license fee of such and such for the year such, also the penalty of the taking to such. From the date of application of license, it is presumed having been carrying on the business legally. This fact has neither been taken into consideration by the respondent deputy. They note the learned almost passing impugned holder award that is such. As such, the impugned holder award is without application of mine and without jurisdiction. There are 16 minor. There is skipping over para 15 because I have quoted in section 116 at page 17. The petitioner begs to state that the learner ombudsman has wrongly based his finding of the on the photos and the photo survey to the effect that the premises used as the godown. Admittedly, the photos were taken by the surveyor on the date of survey, that is 22/7/2020, and not prior to it. In view of the damaged goods lying in the business premises of the petitioner, there existed no reason of ground of carrying on the business on that day. Thus, the photos are not reliable evidence to ascertaining that the business premises was used by the petitioner as a godown and not as a shop or business premises. Next one, my lord. 17. Apart
But
from
how will a photograph help if there is a claim? You are contending that the photographs are post the
yes,
incident. Then what will a surveyor do?
no survey.
Is the surveyor not entitled
Yes,
or the
in that case, it was the duty of the surveyor to have the evidence, other evidence of the neighbor's man, whether it was a business, a shop, or a godown. Your lordship has already gone through the survey report, my lord. He says that he inquired from the neighbors that the goods damaged due to theft. And there is no murmur at all. There is no finding at all that he also inquired from the neighbors whether it was a showroom or a godown. So that it is only the guesswork of the surveyor, my lord. Now, my lord, para 17. Now, my lord, directly I am taking para 18. Not 18, my lord, 19 directly, because signboard of that has not been considered by the surveyor. 19. That the petitive expression contained it is not the case of the respondent that the claim has been repudiated for non-disclosure of material fact. A material fact
Premium for a shop is more than the premium in respect of a godown.
would be relevant for a prudent insurer to fix the premium or to decide whether the insurer should take the risk. The premium for the shop is more than the premium in respect of a godown. So there exists no reason that the lesser premium was paid or taking the risk of a godown instead of business premises. Thus, there is no non-disclosure of a material fact by the petitioner, even if it is presumed that the insurance was taken with respect of a godown. My lord, now your lordship will see the reply in affidavit and opposition. That is very evasive reply. Para 16, my lord. Their affidavit and apply, their paragraph is
Page
page 78, my lord. Para 16A. 78 come up there.
Page number
My lord, just a minute.
of the
78, 78, 78.
Page 78, their
Okay.
affidavit and opposition, my lord. Para 16A. Sorry, my lord.
Yes, 78 only. Reply to paragraph 19.
Paragraph 19, my lord. 16, my lord. That with regard to the statement 19 of the writ petition, the respondent states that the occupancy of the premises is an important material fact. The risks are categorized according to occupation carried out in any particular premises. In fact, the differential system of premium ratings and the underwriting consideration, warranties, and terms and conditions are on the basis of categories of risk only. only neglected to do so. The reason for repudiation claim of the claim was based on sound reasoning. My lord, here is only the clause, so that we need not go any other material for the purpose. For the purpose of this particular claim, it is only the clause. So that general categorization that in case of go down of such and such goods, such and such goods, such and such rates are to be charged. Here is only the clause. The policy was taken in respect of the clause, and it was a shopkeeper's policy. Assuming for the sake of the argument that it was a go down, or it is a go down, my lord, even though the premium which I paid for clothes is more than the premium which is chargeable to go down. That is a specific statement I have made.
What is it? Please, the last part, what did you say?
In this particular case, assuming that it is not a soap,
Is a go down.
it is no soap but a go down. Even though the premium would be lesser, in that case, if the insurance policy is issued to me, it would be lesser
Then a shop.
than the soap. Because that specific statement I have made, he has given the evasive reply
Yeah.
that in case of
Is that an admitted position? Insurance, what is the insurance
yes,
company's take on
he
that?
has taken the evasive reply. What he wants to say, the risks are categorized according. Here is only the risk in relation to clothes and nothing else. Now, my lord, whether it is a material fact or not, first of all, there is nothing in the impugned judgment and order of the learned single judge, as well as the ombudsman, that it is a material fact which I suppress. In support of it, my lord, I beg to refer the certain judgments, my lord. First of all, my lord, I am taking to your lordship first of all, my lord, I am taking to your lordship to the judgment AIR 1964 SC, which has been referred by the learned single judge, my lord.
Yeah, 1964.
64.
Supreme Court.
AIR 64 SC, page 477.
Name?
Name Syed Yaqub.
Syed Yaqub has been referred by the last.
Yes, that's why, my lord. I am taking to your lordship to show whether in this particular case the sorcery would lie or not. Now, my lord, I am taking directly to your lordship to para 7 and 8. And in 7, my lord, if your lordship will come middle of it, that is only relevant. In regard to a finding of fact, middle of it, my lord. Para 7.
Mm.
Have you got it, my lord?
Yes.
In regard to a finding of fact recorded by the tribunal, a writ of sorcery can be issued if it is shown that in recording the said finding, the tribunal had erroneously refused to admit admissible material evidence or had erroneously admitted inadmissible evidence which has influenced the impugned finding. Similarly, if the finding is based on no evidence, that would be regarded as an error of law which can be corrected by a writ of sorcery. In this particular case, your lordship, I have already shown that I applied for the trade license. It was given subsequently. The provisions contained in section 180 of the GMC Act are regulatory, not prohibitory. In that case, my lord, this finding arrived at that whatever the business I was carrying on was illegal, it cannot be said illegal. It is not the liquor business, my lord. Until unless I obtain the license, I cannot carry on the business. So that being the position, my lord, the sorcery is maintained. Now, my lord, the next one I'm going to take to your lordship to 2023 1 SEC, page 428. And paragraphs, my lord, 17, 21, and 42. Seventeen, 21, and 42.
17, 21,
And 48.
48 of 2.
Uh,
42.
Para 18, 22.
No, it says
No,
17.
sorry.
17,
Para 17,
21.
21, and 42. Para 17, my lord. Para 32. Subpara 32, my lord. Make delivery on insurance clauses, insurance to disclose agenda. The insured must disclose to the insurer all facts material to an insurance appraisal of the risk which are known or deemed to be known by the insured, but neither known nor deemed to be known by the insurer. Breach of this duty by the insured entitles the insurer to avoid the contract with insurance so long. I'm giving my lord much more stress on the word.
We have not been able to. 17. Which paragraph?
17,
17.
sub 32. Para 17, 32.
Is quoting Manmohan Nanda.
Uberume fide.
The insured must disclose.
Uberume fide. Utmost
Yes.
good faith.
Now, my lord, only lie. Insured so long as he can show that the non-disclosure induced the making of the contract on the relevant terms. That is very important, my lord. Because there is nothing on the record to show, either insurance company or there, that had I disclosed the fact, the insurance policy would not have been issued. Next one, my lord, same next page, the second paragraph. The aforesaid principles would apply, having regard to the nature of policy under consideration as what is necessary to be disclosed are material facts. This phrase is not definable as such, as the same would depend upon the nature and extent of the coverage of risk under a particular type of policy. In simple terms, it could be understood that any fact which has a bearing on the very foundation of the contract of the insurance and risks to be covered under this policy would be a material fact. So that, my lord, merely for the reason when the premium is lesser in respect of a go down, and there is nothing on the fact. Now, my lord, your lordship is 21, para 21. May I read?
Yes.
On a discussion of the aforesaid principle, we would conclude that there is an onerous responsibility on the part of the insurer by dealing with an exclusive claim. We may only add that the insurer is statutorily mandated as per clause 3 of the Insurance Regulatory and Development Authority Holders Interest Regulation Act, that is such and such. That is such and such. To the effect the insurer and the agent are duly bound to provide all material information with respect to policy to the insured to enable him to decide on the best cover that would be in his interest. Further, subclause B of clause 3 mandates that if the proposal is not filed by the insured, a certificate has to be incorporated at the end of the said form, that all the contents of the form and documents have been fully explained to the insured and made him to understand. Similarly, clause 4 enjoins duty upon the insurer to furnish a copy of the proposal form within 30 days of the acceptance free of charge. Any non-compliance obviously would lead to the irresistible conclusion that the opening clause, it is an exclusion clause, cannot be placed in service by the insurer. My lord, in this particular case, they did not supply me the copy of the form, and I would take your lordship later on. Now, my lord, 46 says,
42.
42 says, my lord.
42.
42. Before we part with the case,
Yes.
we would like to extend a word of caution to all the insurance companies on the mandatory compliance of clause 3, 4 of the IRDA regulation is that any non-compliance on the part of the insurance companies would take away the right to plead the repudiation of contract by placing reliance upon any of the terms and conditions included thereof. Now, my lord, I am taking to your lordship through the provisions of the Insurance Regulatory and Development Authority Act 1999. Which has been referred in this particular case, relied upon in this particular case. Yeah. First of all, my lord, I am taking to your lordship Regulation 2D of the Insurance Regulatory and Development Authority, Protection of Policy Holders Interest Regulation 2002. My lord, this is the book or any other book? This is the book.
You
No,
are,
it's a different.
which act are you reading? Insurance Regulatory and
Insurance
Development
Regulatory and Development Authority,
Act
Protection of Policy Holders.
for Protection of Policyholders.
Interest, policy holders interest, regulation 2020.
এগুলো নাই,
02.
এতে নাই। ভিতরে যদি আছে না জানো।
It is indicated here. Policy holders.
Have you got it, my lord?
Just a minute.
Eight. Page 141. Which section of this act?
The
Regulatory.
Insurance Regulatory and
Yes, yes.
Development
Got
Authority,
it. Which regulation?
regulation 2D proposal, first title.
141.
Proposal.
Yes.
Only explanation, my lord. Material for the purpose of these regulations shall mean and include all important, essential, and relevant information in the context of the underwriting, the risks to be covered by the insurer. Now, my lord, your lordship, I am taking to your lordship to 4, rule 4, regulation 4.
Definition.
Regulation
Definition.
4.
Definition.
Regulation 4. Regulation 4.
That is definition.
Definition,
No, proposal for insurance.
one of the definitions.
4.
Yes.
No, for which proposal form?
No, proposal for insurance.
You are referring to the regulation of 2017.
No, 2002.
2.
Yes. Insurance Regulatory Authority Protection of Policyholders' Interest. Regulation 2002.
This is 17.
Yeah. Have you got it, madam?
But 17 has taken over. There is no 2.
It's not here.
2002, madam. The heading, my lord, the Insurance Regulation Authority, Protection of Policyholders' Interests, Regulation 2000.
2017 Act we've got, but 2002 is checking whether it's still there. Section of
Can you have a look at this?
9.
I think that has been taken over by 17.
Here, 9.
Maybe so, my lord. In that case, my lord, I will.
Mr. Goswami, you also have a look? Mr. Bhati is referring to Act of 2002, but we find that the
not
state
here.
regulation has again come in 2017.
Yes, my lord, 17.
IRDA regulation.
Hmm.
একটু বেলেগ এখন IRDA regulation.
I did too, it is for protection of.
একটু 17.
Ombudsman session. Mrs. Ombudsman.
Mm-hmm.
Yeah, it was very funny.
My lord, it has been
But,
amended.
the reference at paragraph 42 is on the IRDA regulation, not the protection regulation. IRDA regulation is there 2002. So,
IRDA
regulation, regulation,
Whatever.
এইখনটো ঠিক regulation. এইখন। আৰু যে regulation take এইটো।
My lord, most probably it was
Insurance.
amended 2000 by 2017. My lord,
But Mr. Bhatti, if you come to
Yeah.
the judgment which you have just handed over, in paragraph
I
42,
think this is the one.
yes.
Insurance regulator.
Yes, sir. What is the resolution? IRDA regulation, 2020. That refers, my lord, at this one. Insurance Regulatory and Development Authority.
I think there is some mistake. I think there is some mistake. Just a minute.
Oh, my lord, your lordship will come to para 21.
Just a minute.
They have made it clear. Middle of it.
Just give us 2 minutes. বহুত regulation আছে।
In para 21, my lord, in middle of it, they says that IRDA is the Insurance Regulatory Development Authority Protection Policy Holders Interest Regulation, 2022.
What is this reference at page, paragraph 42 of the judgment? Before we part with this case, we would like to extend a word of caution to all the insurance companies on the mandatory compliance of section clause 3 and 4. What is this 2002 regulation? Do you have?
Yes, my lord, I have.
Let us see that.
Yes.
File on the Corona Gate. Yes. No, this is not the IRDA regulation. This is IRDA within bracket protection of
My lord, if your lordship
protection of
will,
policy.
if your lordship will come to para 21 of the judgment, in that case, your lordship, they have referred the IRDA, they refers to Insurance Regulatory and Development Authority Protection Policy Holders. Middle of it, fourth line, third line, para 21 of the judgment. In short, it is called IRDA regulation.
Just a minute, please.
21. para.
Yes. But this 2002, the judgment is of which year?
2023.
23. Perhaps the subsequent
Yes, amendment was not taken into
was not
consideration.
was supposed.
Yes,
Perhaps it was not brought to the notice of this
yes.
court.
my lord, may I pray this is let it be kept as pardon and let it be fixed on Monday. And I
No,
would,
Monday this bench will not be there.
Sure. Bitten.
Then tomorrow, my lord. Tomorrow.
Next week, Tuesday. Eat. No, oh, no, next week we are there. I don't know. Next week we may be there. Next week, then
Yes.
week thereafter, there's
Yes. And let it be kept as the part.
Porter will not say.
My lord,
Porter-
I
No,
ask
no,
you,
we'll, if this bench is there, definitely will be listed for us. Mr. Goswami, let us try on Monday then.
Monday,
Monday, next Monday.
22nd.
Monday will be 25th.
20.
25th. Okay. On a joint request made by the then. 25th, Monday. On a joint request made by the learned counsel for the parties. List for admission hearing on 25/5/2026. If this bench is there, it will come before us only.
Yes.
You can take this book. It will move away. Kindly check with the other one.
Yes, yes, my lord. No problem.
But we are not treating this as part of.
Eh?
If we are not treating this as part of, if it comes, we'll do it.
No problem.
May I please, your lordship?
Yes.
In item number 3, lordship, I have filed one interlocutory application for extension of times to appear, to allow me to appear before the superintendent of police. Here, lordship, interim order was granted on 18/3/2026, by which, lordship, 10 days was given to me to appear before the superintendent of police. Thereafter, lordship, in the cause title, lordship, inadvertently, we had made superintendent of police Jorhat as a party respondent, whereas the superintendent of police Shivsagar ought to have been made as a party respondent. We had preferred one interlocutory application that was allowed, page number 41A. Now, lordship, the superintendent of police Shivsagar is a party, page number 15. So by that time, lordship, the 15 days has gone by, lordship. Lordship, may kindly allow me 10 more days time to appear. I will appear. And this time, superintendent of police to follow Yasila, I file to receive your call. Après, la position.
Yes.
Yes, document.
Heard 3M Ahmed learned counsel for the petitioner. Also heard also, huh? By the present petition, comma. Yeah, I hate the petitioner has prayed for extension of time for appearing before the concerned authority as directed by the order dated 18/3/2026 passed in the connected WPC 1623 of 2016. Full stop.
26.
2026. Para. It is contended that void the aforesaid order dated 18/3/2026, while notice was issued, the petitioner was granted bail subject to his appearance before the Superintendent of Police Border, Jorhat within 10 days. Full stop. Subsequently, it came to the notice of the petitioner that the concerned authority would be the Superintendent of Police Border, Golaghat. Sibsagar. And accordingly, I 1079 of 2026 was filed, which was also allowed by this court wide order dated
8/4/26.
8/4/2026. Full stop. Para. The Sri Ahmed the Learned Council has submitted that in the meantime, the period of 10 days has expired, and therefore he prays for extension of time. Para. Sri Sharma, the Learned Counsel for the Home Department, has not seriously objected to the aforesaid prayer. First up, he, however, has submitted that a final opportunity be granted for such appearance. Para. In view of the above, the after considering the facts and circumstances and hearing the hearing the learned counsel for the parties, we are of the opinion that interest of justice would be served if an extended date is given to the petitioner, to the applicant / writ petitioner, to appear in terms of the order dated 18/3/2026. We accordingly direct the petitioner to appear before the Superintendent of Police Border, Sibsagar, on or before on or before 1st of June 2026. Full stop. The conditions imposed wide the order dated 18/3/2026 would be applicable provided the applicant petitioner appears in terms of today's order. I stand disposed of.
Highly applaud.
Item 6. Item 6. J. Mullah. 17 matter, J. Mullah. None appears for the petitioner on call, whereas Prince appears. Even on the last occasion, that is 21/4/2026, the petitioner, there was none, the petitioner, none had appeared for the petitioner. This writ petition is pending since the year 2017. First up, it appears that the petitioner has lost interest in this case. In view of the above, the writ petition stands dismissed. Interim order passed earlier stands vacated. Records be sent back along with a copy of this order. 7.
May I please, Your Lordship? In plain opinion, starting from page 9, my lord.
page 9, and the relevant portions will be page 12, my lord. My name is Hazera, my lord. To page 12, my lord. The last ultimate 2 lines, my lord. To establish,
Just a minute.
I'm sorry, my lord.
Page 12.
Page 12.
Hazera.
Yes, my lord. 8,
Khatun. Yeah, Hazera Khatun.
Hazera Khatun and Hazera Begum. Primary questions is, my lord,
Hazira, not Hazera. Hazira.
Hazira.
Zedai.
Jira. Primarily to establish my linkage with my father, my lord, I have relied 3 documents, my lord. One is the voter list of 2010, and one Gaubura certificate, and another is GP certificate. And
What is your date of birth or year of birth?
My lord, here, even my lord, as far as WS goes, my lord, nothing of that sort has pleaded in the petition, my lord.
But year of birth from deduction from anything, any document.
39 when I was in the year 17, my lord.
So what would be your year of birth? 2017. 17. Oh, sorry. Around 1979, perhaps.
79, 80, my lord. Before going to that contention, my
Written
lord,
statement filed when?
on time, my lord.
Date.
Date, my lord, there it is in the LCR, my lord. Date, unfortunately, my lord, in the second page, my lord, of the written statement, what I have gathered from the LCR, my lord. Primarily, my case is, my lord, on a.
Now we want to know when the written statement was filed. Just give the date. Or
LCR as a date. LCR, yep. LCR to it.
okay, we'll come back at 2 o'clock, Mr. Tapada.
Date is not here.
Date is not there.
No.
Maybe the tribunal has recorded the date in the impugned opinion. Okay, 2 o'clock.
Obligement. When the WS was filed, my lord,
Yes.
I have carefully gone through this, my lord. Only thing that noting of the learned tribunal member is seen on 15/10/2015.
Okay, 15,
10/2015.
2015.
Yes, my lord.
WS page?
And this is there in the
Record.
LCR, my lord, record. Page 20.
You have not enclosed the WS.
Page 20. Page 16. 16 and 17.
Okay.
Here, my lord, in the premise that I was not able to establish my linkage with my father. To establish my linkage, I have produced 3 documents, my lord. One is the voter list of 2010, my lord, admittedly with my father, my lord.
Page.
Here in LCR, my lord, unfortunately, that document is not here, my lord.
You have not enclosed any
Enclosed,
documents
my
with your writ petition.
Writ petition, it is not there, my lord. And this is not in any way helpful for me, primarily for the reason because it is not with my father, my lord, with my husband. And then to link with my husband, my lord, again, there is a certificate issued by the government Gaubura, my lord. That was not proved. And again, the second certificate that I have enclosed was the GP certificate. Again, it was not proved, my lord. That was the finding of learned tribunal is page 12, my lord. I'd just like to read out. Moreover, exhibit 4 and 5.
No, you need not read out. You at least place those documents. What are those documents? Let us have a small note.
Yes, my lord. The
For
page,
this-
page
for-
16. Page 16
The
have a look
records.
of my writ petition, my lord.
Record page 19.
Unfortunately, it was not proved, my lord.
Page 16 is what? Gaon Panchayat.
Gaon Panchayat, my lord. Not proved, my lord.
16. 3/7/15. GP certificate.
Yes, my lord.
Was it marked?
Was marked, my lord, but not proved, my lord.
Nobody came to prove it.
No, my lord.
The petitioner,
No.
she also did not prove
No.
it. Did she deduce evidence?
Yes,
How many witnesses were there?
Only one.
Only one, my lord. Herself, no?
News.
This Gaon Panchayat certificate was not even tendered. Was it tendered or not?
Exhibited, my lord, not proved.
Exhibited.
Yes, yes.
And it was tendered, but not proved.
Not proved, my lord.
Exhibit as exhibit.
Exhibit 4, my lord. Yes. And
Then-
second is the Gaubura certificate, my lord. Again, not proved, my lord.
Page
In the record,
18.
Record
20,
page 30.
27, 12, 2015.
it is not the
Sarkari
certificate.
Gaon Board certificate.
It is not the certificate, my lord.
Exhibit 5.
May I come, My
Exhibit
lord.
5, yes.
my lord, with sincere apology, my lord. This is not the certificate exhibited, my lord. Certificate exhibited there in the LCR. Why I am not emphasizing on this? Because this is obtained after the opinion rendered, my lord.
LCR page 32.
Page-
Gaura 32.
Page LCR, page 32, my lord.
Date
18/9/2015.
LCR.
Page 32.
Okay.
So primarily 3 document, my lord, to
And the
establish
third one,
is the Bhutan list of 2010, my lord.
have you enclosed in the writ petition?
Here it is, even though it's mentioned, but I was not able to procure that document, my lord. It is there in the LCR again,
Voter list of
2010.
2010.
Right,
records page,
page 33.
Exhibit 3.
huh?
Record
33.
page 30.
Page 30 of
30.
records.
Exhibit 3.
Who's there?
With my husband, my lord, not with my father, my lord.
Age?
Age to
What is written?
Is
No, Hazira,
32.
name.
32.
Name.
Hazira Khatun. Swami Aftar Uddin.
Hazira Khatun is 32 and Akhtar,
Aftar Uddin is 47.
village,
Village Sarlok.
Charlock.
Sherlock.
Out of these 3 document, my lord, voter list admittedly with my husband after my marriage, my lord.
When was the marriage?
Marriage here, admittedly, the date of marriage is not mentioned here in the certificate itself.
Year of marriage.
Year of marriage is also not mentioned, my lord.
He is not remembering lordship, giving evidence lordship. He deposed. He is not recollecting all these things lordship.
What did she state in the evidence?
Evidence same thing as that of WS lordship, that Sir, I am bona fide citizen of India by birth, residing in the above noted address permanently. This is permanently. That, sir, my name is enlisted in the voter list of 2010. Jamuna Mukh LSC, 5 part number so and so, as Hajira Khatun, wife of Aftaruddin, in the voter list of 2014. Same lordship. That, sir, my father's name is enlisted in the voter list of 1966, Jamuna Mukh as Muhammad Asaf Ali, and 1970 as Ahmed Ali. But here, lordship, there is this vast difference between these two voter lists.
This is
That, sir, the case has filed against me falsely without investigation, so it is liable to be dismissed. That, sir, I am bona fide citizen of India by birth, not foreigner, so the case is not liable. Case is liable to dismiss. That I am sharing this affidavit as
Okay.
a sheaf of evidence of above mentioned case before the learned court. That much only.
primarily relying on these two documents, my lord. Admittedly, I am not emphasizing on 2010 and 14 because this is not the certified copy. This all photocopies, my lord. And then to establish my linkage with my father, two certificate, unfortunately, for whatever reason, my lord, marked, exhibited, not proof, my lord. Other than these two documents, my lord, I'm afraid I'll not be able to make up my case, my lord.
Okay. We'll close this then. We'll dismiss it, but we'll look into the records.
Yes, my lord. Here, one thing, my lord, just, I'm sorry, my lord. Here again, the reference and the initial by the superintendent of police, it is 66 to 71, my lord. And in LBA report also 66 to 71, my lord. 8 and 9 page of the LCR, my lord.
On
And-
what do you say on this reference part, Mr. Sharma? In few cases
Yes,
that
bro.
what was that?
No.
Ananda, not Ananda.
This is properly with respect to what we can't. And
But here he has got a he has tried
Here
to make out a case that even in the reference.
lordship,
67.
yes, lordship, regarding that, lordship, I want to rely Rukia Begum's case, lordship, Rukia Begum Borbia. WPC 2279 of 2021.
2279/21.
Reported in 2023 for GLT 1208.
2023.
For GLT
1208.
Yes, Lord. So, ultimate proposition is that lordship,
What paragraph?
lordship paragraph.
Nice. 8, 9,
Paragraph
7,
7 is
8, and-
imported. 7, 8.
What is the proposition?
13 onwards. Lordship, tribunal can go beyond reference, lordship.
Beyond reference,
Yes,
the
sir.
earlier, earlier, during, the, Santosh
Yes.
classes with the
Yes,
reference.
it was discussed, lordship.
And,
Here, lord-
the other one is with regard to notice, it is permissible to change the street, but reference is not permissible.
yes, lordship,
As per
reference is
Santosh.
not permissible, but Rukia Begum says that
It is
it
permissible, so
is
there is a
permissible.
conflict into the street.
No, lordship, it is discussed properly, lordship, from 13. Onwards, Lordship. Earlier, Lordship, Thalani Bibi's case was discussed here, Lordship, and Thalani Bibi is based on Santosh's case, Lordship. Very elaborate judgment, Lordship.
Okay.
From reading of the provisions in paragraph 16 of the judgment of Thalani Bibi Supra, it is discernible that in the said matter, a reference was made as to whether the person.
Sorry to interrupt. Which paragraph?
Para 7, I am reading. Lordship.
Rukia Begum.
Rukia Begum Borgia.
Oh, please proceed.
After discussing, Lordship,
Naam to give. What was the name you had said? Rukia.
Rukia Begum Barbhuiya alias Rukia Begum Rukia Begum. From a reading of provisions in paragraph 16 of the judgment in Thalani Bibi Supra, it is discernible that in the said matter a reference was made as to whether the person concerned came to the state of Assam from the specified territory between the period 1/1/1966 to 24/3/1971. But upon considering the materials on record that had been produced before the tribunal by the proceeding concerned, the tribunal was of the view that the person concerned had entered the state of Assam from the specified territory on or after 25/3/1971. In these circumstances, the tribunal declared the person concerned to be foreigner by arriving at a conclusion that the Foreigners Act 1946 or the orders framed thereunder do not bind the tribunal to the terms of the reference. This said view of the tribunal was assailed in the writ petition in Thalani Bibi Supra, and while adjudicating the said writ petition, the court had formed the views as provided in paragraph 16 thereof, which are extracted herein above. A reading of paragraph 16 of the judgment in Thalani Bibi Supra makes it discernible that the court had gone into the question that the tribunal derives its jurisdiction to answer a reference under order to one of the Foreigners Tribunal Order 1964, and therefore it cannot be any question which may be beyond the reference that had been made. As the reference was made in Thalani Bibi Supra as to whether the person concerned had entered the state of Assam from the specified territory between 1/1/1966 and 24/3/1971, therefore the tribunal could not have answered the reference by holding that the concerned person entered the state of Assam from the specified territory on or after 25/3/1971. Conceptually, we are in agreement with the view in Thalani Bibi Supra that a tribunal cannot answer a reference beyond the reference that has been made to it. But at the same time, we are also required to look into as to what could be understood to be a reference made to a tribunal. To answer the question, we are required to look into the provisions of Rule 2(1) of the Foreigners Tribunal Order 1964, which is extracted as below. Constitution of Tribunals. The central government may by order refer the question as to whether the person is not a foreigner within the meaning of Foreigners Act 1946 to a tribunal to be constituted for the purpose for its opinion. A reading of Rule 2(1) of the Foreigners Tribunal Order 1964 makes it discernible that central government may by order refer the question as to whether a person is or is not a foreigner within the meaning of Foreigners Act 1946 to a tribunal constituted for the purpose. This statutory provision of Rule 2(1) makes it explicit that the reference to be made by a tribunal would be the question as to whether a person is or is not a foreigner within the meaning of Foreigners Act 1946. Section 2A of the Foreigners Act 1946 defines foreigner to mean a person who is not a citizen of India. In other words, going by the meaning given to the expression foreigner under Section 2A of the Foreigners Act 1946, a reference to the tribunal would be as to whether the person concerned is a citizen of India or he is not a citizen of India. To understand the concept of being citizen or a foreigner in respect of such category of persons who entered the state of Assam from the specified territory, who is, in other words, would require an appreciation of the provisions of Section 6A of the Citizenship Act 1955. Section 6A of the Citizenship Act 1955 is extracted as below. So 6A was quoted here, Lordship. So I think Lordship 6A is not required to read, Lordship. After that, paragraph 12, a reading of the provisions of Section 6A makes it explicit that it is a special provision as to citizenship of persons covered by the Assam Accord, and core provisions of Section 6A are that a person who may have entered the state of Assam from the specified territory prior to 1/1/1966 shall be deemed to be a citizen of India from the 1st day of January 1966. The further provision is that such persons who entered the state of Assam from the specified territory after 1/1/1966 but before 25/3/1971 from the specified territory and has been detected to be a foreigner shall register himself with the foreigners registering authority of the district concerned, and upon having been registered shall be debarred of any voting rights for a period of 10 years, but otherwise retaining all such other rights that a citizen of India may be bestowed with under provisions, and further that upon expiry of the period of 10 years, even the voting rights would be restored back. In case of persons who had entered the state of Assam from the specified territory on or after 25/3/1971, such persons are to be declared as foreigners. In para 13 is important, Lordship. In view of the provisions of Section 6A of the Citizenship Act 1955, Clause 2(1) of the Foreigners Tribunal Order 1964 would now have to be understood that once a reference is made, the reference would be whether the person concerned is or is not a foreigner, meaning thereby whether the person concerned is a foreigner who had entered the state of Assam from the specified territory on or after 25/3/1971, or he is a person who belongs to any of the other categories, that is, a person who entered the state of Assam from the specified territory before 1/1/1966 or between 1/1/1966 and 25/3/1971. No other meaning can be attributed to the reference under Clause 2(1) of the Foreigners Tribunal Order 1964, that is, whether a person is or is not a foreigner within the meaning of the Foreigners Act 1946. We further take note that even if a reference is made by setting up a question whether the person had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971, the reference would have to be understood to be a reference under Clause 2(1) of the Foreigners Tribunal Order 1964. That is, as to whether he is a foreigner or not. If the reference is worded whether the person concerned is a person who had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971, in order to arrive at any such conclusion, that a reference itself is faulty inasmuch as the decision of the tribunal upon the materials on record would be that the person concerned had entered the state of Assam from the specified territory on or after 25/3/1971. In such circumstances, the only situation that can be envisaged is that the tribunal first arrives at a conclusion of its own that the person concerned had entered the state of Assam from the specified territory on or after 25/3/1971, meaning thereby that a reference itself had been answered by the tribunal. After having answered the reference, it would be an inconceivable situation that merely because a reference is worded well, whether the person had entered the state of Assam from the specified territory between 1/1/1966 and 25/3/1971, it has to be referred back to the referral authority to make a fair reference, now putting up a question whether the person concerned had entered the state of Assam on or after 25/3/1971. In such situation, as a matter would have to be referred back only after a final decision has to be arrived at. And now, if the reference is again made with a corrected expression in the question frame, the same may be lead to further complications that the subsequent reference would be barred by principle of res judicata, in as much as it would be a subsequent reference on the same issue between the same set of parties where an earlier decision had already been arrived at. It is noticed that Falani Bibi Chopra, the aforesaid aspect of the further implication of a corrected reference being again made and not been gone into. And from such point of view, it can be said that the view taken thereon would be par inquirium of the further consequences of a fresh reference being made. After that, Lordship,
That means this decision is in a way explained.
yes,
Santosh,
yes, Lordship.
And held that actually, not in so many words, but held that it is not contradictory to that.
Yes,
That
Lordship.
has been explained.
Yes, Lordship. So, Lordship, so many paragraphs are there, Lordship.
Okay, you have given the paragraph. You just mark the paragraph. Give the paragraph.
Para 13, 16, Lordship.
Just a minute, please.
Para 13,
13,
13, 14, 16, and 17, Lordship. In view of above, as the principle of parenquirium is more applicable rather than it being the principle of stare decisis, the principles laid out in the paragraph 13 of Ajay Sharma Supra can also be answered accordingly. 17 is also important. 17. So, Lordship, if we see in this case on merit, Lordship, and then if we gone through the WS, Lordship, WS, her father's name is different, Lordship. He projected one Asab Ali as his father, Lordship. On the other hand, Lordship, in evidence, she said that Lordship Ahmed Ali, whose name reflected in the voter list of 19...
WS, what was said?
Lordship, in WS, he said that my father's name is reflected in the voter list of 1966 and Asab Ali.
Asab.
Asab Ali.
But
whereas in evidence, in WS 1970 voter list was not reflected, Lordship, but in evidence he again relied on a voter list of 1970, Lordship, where one Ahmed Ali's name was appearing, Lordship. Not Ahmed Ali, one Ahmed Ali's name, but he stated that, Lordship, this Ahmed Ali is her father. But, Lordship, we see the voter list of 1966 and 1970. These two persons are different persons because, Lordship, in 1966, Muhammad Asaf Ali's age is 24 years, whereas in 1970 voter list, this Ahmad Ali's age is 50 years. So it cannot be, Lordship. And again, Lordship, one Sorguna Bibi name.
what is the name of the person in 2070?
Ahmad Ali.
Ahmad.
Ahmad, not Ahmed. Ahmad Ali.
Okay.
And one Sorguna Bibi's name is reflected lordship, who is this Sorguna BB lordship? It was not explained anywhere. Whereas in Gao Pansat certificate, she is relying it as exhibit number 4. Here, her mother's name is specifically reflected as Aybut, AYBUT, Aybut Nessa, NESSA, page 31 of the LCR. But in WS Lordship, only 5 paragraphs WS Lordship, this is, nothing has been mentioned Lordship. Who, place of birth, date of birth, name of the parents, Lordship, grandparents, mother. Only thing is that Lordship, my father's name was reflected in 1966 voter list as Asab Ali. And in WS, 1970 voter list was not reflected, and said that nowhere, no statement is there, Lordship, regarding that this 1970 Ahmad Ali and 1966 Asab Ali are same and one person. After that, Lordship, no document is there. After that, she relying Lordship 2010 voter list with
But
her.
those are not exhibitor approved.
It is
2010.
2010 exhibited, but it is with her husband, Lordship, not with her father.
2010, yes.
With her husband.
Exhibit 3.
Exhibit 3. So, Lordship, my humble submission is that at this stage, Lordship, opinion may not be disturbed, Lordship, and I think, Lordship, there is no infirmity in the opinion passed by the learned tribunal. And Lordship, if we see the cross part, Lordship, at page 26.
Records.
This is
Records.
Records.
Records. Page 26.
26.
Yes, Lordship. মোৰ নাম মছম্মদ হাজিৰা খাতুন, মোৰ অনুমানিক বয়স 26-27 বছৰ হ'ব। মোৰ ককা দেউতাৰ নাম মাসুদ আলী আৰু মোৰ ককা আইতাৰ নাম মোহাম্মদ মেহেৰজান, মোৰ দেউতাৰ নাম আহমদ আলী আৰু মাৰ নাম সৰগুল বিবি হয়। But here he is stating that her mother's name is Sorgul Bibi, whose name reflected in the voter list of 1966. But Lordship, at the same time, Lordship, she is relying Gao Pansat certificate where her mother's name was specifically written as Aybut Nessa. So, মোৰ দেউতা মোৰ বিয়াৰ পিছতে মৰি যায়, কিন্তু মোৰ বিয়া কেতিয়া হৈছিল মই নাজানো। মোৰ মাৰ বৰ্তমান বয়স 105 বছৰ। তেওঁ বিচনাৰ পৰা উঠিব নোৱাৰে। মোৰ বিয়াৰ আগত মই হাইলাকান্দিত আছিলো। মোৰ জন্ম তাতেই হৈছিল, কিন্তু হাইলাকান্দিৰ কোনটো গাঁৱত মোৰ জন্ম হৈছিল সেই গাঁও নাম মই নাজানো। বিয়াৰ সময়ত মোৰ বয়স 18 বছৰ আছিল। বৰ্তমানে মই স্বামীৰ ঘৰত অৰ্থাৎ চাৰ্লোক গাঁও যমুনামুখ থানাৰ অন্তৰ্গত মই থাকো। But Lordship, she was born at Hailakandi, Lordship, but there is no document at all to show that Lordship she is born and brought up at Hailakandi. Even 1966 and 70 voter list of district Nagaon district, Lordship. So if again, Lordship, if we calculate the age, Lordship, she was at the time of cross-examination 26-7 years approximate age, Lordship. She was sometimes born in the year of Lordship 1989, if that be so, Lordship. In the year of 2015, he was 26 to 27 years approximate. Then if we calculate the age difference between father and her lordship, comparing with the 1970 voter list, that it will be about 69 years. So, so it can happen or not, I don't know, my lord, but lordship, the proceedings no way connected with the person whose name reflected in the voter list of 1966. That's all, lordship.
Write his name, huh? And this is Tapadan G. Sharma. And Kolita. Mr. Kolita, you are a standing counsel. You appear on AIB. Yeah. We thought you were a standing counsel. দেখিলে হয় কার কার আছে নামটুকু করেছে ওকে
I'm developing.
K. Parasha, CGC, and Government Council to P. Sharma was there. R.B. Bora, Miss R.B. Bora, State Council. Wait, please, Worship. Khatun, Ilyas Halima Khatun. Date of birth, she was 52. She was 52 in 2019. I'm giving that. (1967).
You print statement. Page 29, my lord. It was filed on, my lord, 25/10/2018. 25/10/2018, page 29. But it is a contested case, my lord. And judgment is very short judgment, my lord. Your lordship would be pleased to turn to page 47. 47. From 47 it starts, my lord. Exhibited documents, my lord, 1, 2, 3, 4, 5, 6. 6 documents exhibited, my lord. I'm giving, my lord. Exhibit 1, voter list of 1967, 65. Page, my lord, voter list page, my lord. I'm referring to only exhibit, my lord. I'll go to that voter list, my lord. Exhibit 1. By 1. Yes, my lord. Then your lordship would be pleased to turn to page 15. Yes, ma'am. One five. Mumtaz Ali. Mumtaz Ali is the father of the proceeding. And Zoimon Nessa, her mother. Now your lordship would be pleased to see page 17. Page 17, my lord. Page 17, exhibit 2, that is voter list of 1970. 17, my lord, page 17. 1970, exhibit 2, and name appears at page 18, my lord. Mumtaz Ali. Milanesa, mother. Name, there is some difference of name, my lord, but mother. My lord. My lord, Abbar is elder brother. Eldest brother. Eldest brother. She has 4 brothers. Zabbar is the eldest.
and Sheikh Jabbar, my lord, reduced as DW2. My lord. My lord, one is discrepancy, my lord. My humble submission before your lordship. It is common in the electoral law all over Assam, and Honorable Supreme Court also, my lord, some decision held that in Assam and respectively in northeastern region, there is some discrepancy in name and race. Common. My lord, here also your lordship would be see that father name sometime Montaz Ali, sometime Mustafa. This discrepancy also there. Sometimes it so happen, my lord, earlier voter age is something and it is not tallied with subsequent voters. No.
But here, when a mother is found, name are required.
Well,
One would
my lord, that's it. That is their matter.
that is cannot
My,
be checked.
my lord, my humble submission before your lordship to this point that voter list is prepared by the election commission. So, my lord, supposing earlier voter list, election commission, it was the duty of the election commission to tell it with earlier voter list. Without telling the earlier voter list, my lord, what has been collected by the enumerator at that time, my lord, that has been recorded again. That is the what?
In that case,
Next question, your lordship will ask me. The Mr. Sheikh, there is provision in representation of people. My lord,
you cannot hold their provision.
my lord, my lord.
Let us assume that while enumerator
65 voter list. Well, to that, my lord, I am unable to answer because, my lord, I'm the younger sister among the four brothers, my lord, four brothers and myself. So, my lord, I was at that time very young, and whether my brother's name entered into 1965 electoral roll or not, my lord, if I am asked for this, my lord, I am unable to answer. I am not in a position to answer this. That is my reply to your lordship. Well, six. No, not. Yeah. My humble submission before your lordship. My explanation is this, my lord, I am unable to. One, my lord, no what to explain. Now your voter list, your lordship would be pleased to turn to page 19, my lord. This is the detail, this is the voter list after my marriage, my lord, where my name appears. 1989 voter list, page 19. E- 89,
19 years
my lord,
after 1970. This is correct.
1970, my lord. No, I'm referring to 1989 voter list. Yes, ma'am. 1970. My lord, 19 years gap, all right, my lord. At that time, I entered into marriage. It is another thing, my lord. Another chapter started. I entered into marriage. So, my lord, my name entered into the voter list along with my husband. So, my lord, this gap period, possibly I was minor at that time. Page 19, my lord.
1970 also.
Yes, 70 in 89, my lord.
71 of them.
But after 70, my lord, I could not produce any voter list. I have gone through voter list of 1989.
Who is you have seen at this bench?
Page 20, my lord.
Who you have seen?
Yes, sir. My husband, my lord. Let me clarify. Who is yes, yes.
Husband.
Yes. Yes. Just 1 minute. ma'am. He has seen his husband, my lord. He has seen husband. Sidon, maybe another word, my lord. Yes, another word. That is this, what is called Shotin. Two words. Because, my lord, against Basidon also, yes, in his detail. Well, that I am to check down. I am to check down. My written statement, my lord. At page 29. Maybe. It seems, my lord, from report. Not a speculation, my lord. My lord, regarding this, my lord, I am to check up this WS, whether I have stated or not. No. Halima. Halima Papa. My lord, no. No copy, no. But regarding marriage, my lord, only I am to depend on DW2 and DW3. DW2 is my eldest brother. Yes. W2 is my eldest brother, Jabbar Ali, whose name appeared in 1970 voter list along with my parents. DW3 is my another brother, Shukur Ali. Yes, ma'am. Is popular Shukur, not that popular Shukur is.
M. Dubri.
Thereafter, your lordship would be pleased to see 1997. Page 21. 21, 22, 22, Yasin Ali, then Halema Khatun. My lord, these are the documentary evidence, my lord. But your lordship, some documents I filed, that is, my lord, Kamura certificate, that is at LCR page 42. Of the LCR, my lord. But Gamura certificate page, I could not annex with the writ petition, my lord, at page 42 of the LCR. That is from village Thekagaon. She lives in Thekagaon also. Page 42 of the report.
Lords.
My lord. Date of the certificate, my lord, I'm to say from Mr. Sharma will say from the court. It's 42. Date of certificate. It's 42.
Page 42. Two Gauhati certificates are there. 42 date to be satisfied. 4818.
4818. But another Gamura certificate page 43. A record. Each of village Nis Domoka Bandokwa. Lord Nis Domoka Bandor Khoa. Bandor Khoa. Earlier one, Thekka Gaon.
Kopahartari. Earlier one. Kopahartari. Village.
Kopahartari.
Page 42 is a village Kopahartari.
Oh. 3 is Nis Domoka. Niche Domoka Bandurkwa.
Village is 43, 22. Page 43, village Bandorkhwa,
Bandurkwa. Date of issue to
date 8/8/2018.
8/8/2018. Because my lord, she sometimes resides in that village and sometimes here. Because my lord, she was originally in the bank of river Beki. Beki eroded away and thereafter shifted one place to another place. Short time, sometimes reside there like this.
This certificate is stated that Lordship, he is married to one Yasin Ali of village Bandorkhwa, and this is residential certificate issued by Gaubra of that Bandorkhwa village.
Now, my lord, another certificate issued by the secretary, VP secretary, page 44 of the LCR. Page 44 of the LCR. VP certificate, page 44, posting Pakagaon. Pakagaon.
Yes. Yes, Lordship.
Oh, my lord, sir. These certificates, my lord, my humble submission before your lordship. Only submitted, this is not proved. This is not proved because the secretary, the Gaura, were not examined. Now, my humble submission, my lord, I am leaving to your lordships whether in any way some reliance can be given to these documents, taking into consideration the other circumstances. So, my lord, my first submission before your lordship that parents, no doubt, there is no doubt about it. They are the citizen of India. Establishing linkage, I'm to rely on my brothers now. Because, my lord, two brothers, they depose that she is our sister.
Yes, Lordship. Yes, enclosed Lordship. 29 of the repetition, Lordship. Yes, Lordship. Yes.
Written statement, yes. But your lordship held that proceedee is duty bound to elaborately submit the written statements. As per decision of this honorable court, it is the duty cast on the proceeding to narrate his case, elaborate written statement is to be submitted. So my humble submission before your lordship, what written statement has come in at page 29, annexation 9, he elaborately stated where from she has come, where she was born, how many brothers, sisters, how many brothers he had. A elaborate written statement has been submitted from which now your lordship would be pleased to see it is a Indian order is very short, 2 pages judgment, my lord. That is at page 47. Here, my lord, I want to point out only one thing. In the middle, my lord, evidence of about yes, evidence of OP DW1 and that of her brother Jubbar Ali DW2 was recorded on 19/3/2019 and 10/4/2019 respectively. There is the evidence of both. Here, my humble submission before your lordship, I also adduce evidence of DW3, my another brother, my lord. The learned tribunal, my lord, taken into consideration DW2, my own brother. The DW3 is not taken into consideration. Now, your lordship, turn to page 48, my lord. Summary, my lord. Headline is summary. Now, your lordship will go serial number 4, point number 4. Page 48, my lord. Summary. Headline is summary. Now, your lordship will go to point number 4. OP's projected father Mumtaz Ali and his wife Joymunnesa are deemed citizens of India. Clear finding. OP's projected father. So that their names found in voter list of 65 and 70. Exhibit 2. However, name of Joymunnesa has been spelled out as Jamila Nessa. So, my lord, learned tribunal got some discrepancy in name. Anyhow, my lord, it is said that Mumtaz and Joymunnesa, my parents, are seems to be citizen of India. Now, your lordship, main blow to me, my lord. Point 6. OP's claim lineage from his projected father Mumtaz Ali and mother Joymunnesa. Exhibits 1 and 2 are not proved. Could this, my lord? My only reply to your lordship is this. My 2 brothers adduced in my favor that she is our sister. And on that support, my lord, I will rely on Section 50 of the Evidence Act.
We see the voters list, Lordship. 1970 voter list, one Jabbar Ali's name appeared and connected person's name is Mustab. If we ignore that Mustab, Mustab is not Montaz Ali, Lordship. Then Lordship. No. Yes, Lordship. So, if we ignore that, Lordship, also, it is again of different place, Lordship. It is an earlier 1965 voter list is of Koyagosi Pothar. This is different. If we ignore this, Lordship, then also there must be some document which indicates that Jabbar Ali is a citizen of India, Lordship. But Lordship, after 1970 to 1997, there is nothing in respect of Jabbar Ali, Lordship. So, Lordship, again, if we calculate the age, Lordship, this Jabbar Ali was aged about 25 years in the year of 1970. May I submit, Lordship? 65 and 70 voters basic. Almost same. There's a marked difference. 65 and 70 voters. Yes. You can't see the origin. 65 voters is perfect for Montaz Ali, whom the petitioner projects to be her father.
Father.
And on Jayamanasa. Jayamanasa. Jayamanasa is the mother. Mother. Okay. Now they are shifted out. Yes. 65. Let us assume that they have shifted. Yes. To co-partner. 1970. 1970. Montaz is there. Yes. Montaz is the son of Bhajan. Bhajan.
Bhajan.
Jamila Nessa. Yes, correct. Nessa becomes Jamila Nessa. And other than Mustab. Mustab. And this Jabbar Ali is the son of Mustab. Yes. Not Mustab. We cannot say that that one Jabbar is the son of Jabbar Ali is the age. Yes. Yes. Jabbar is the son of Jamila. That's just the Jamila.
My lord, regarding this name, my lord, I have tried to explain in my written statement that name has been written like this. In the written statement. Oh, my lord. My lord.
This is when the name first came to Montaz Ali. Thereafter Jamila Nessa.
My lord.
Why was Mustab?
My lord, your lordship will consider. I am not relying on that. Jabbar is the son of this Jamila Nessa. No, my lord, my thing is this, my lord, your lordship will consider the age difference with Montaz and this Jabbar. Because regarding, my lord, I am not relying that Jamila Nessa is not my supporting document. My document is this, my lord, my father's name is Montaz Ali. Who is my mother, my lord? Who is my mother? That is not the issue. Issue is this, Montaz Ali is my father. And Jabbar is the son. Jabbar,
Jabbar Ali, my lord, Jabbar is Mustab. No, my lord, your lordship would see. Montaz Ali. I'm referring, my lord. Subject to correction by your lordship. My lord, your lordship at page 16. First, your lordship will place Montaz Ali. Montaz Ali, Montaz Ali. Now, my lord, 1 point. Montaz Ali, son of Bajan Ali. Next, my lord, Montaz Ali, son of Bajan. So, my lord, this Montaz Ali is a correct name. Montaz Ali Bajan. It is 65, my lord. So, Montaz Ali Bajan means this Montaz Ali, son of Bajan. Jabbar, my lord, Jabbar Ali, son of Mustaf. Here, my lord, name of Jabbar Ali is wrongly written. That I will prove by your lordship. Your lordship will go to just 1 minute, man. Your lordship will turn to page 25. That is why, my lord, I submitted before your lordship that name discrepancy is always there. Page 25. Page 25. Jabbar Ali, son of Montaz. My lord.
But,
Yes, that was exhibited.
but lordship, if we see the,
My lord. So, my lord, my humble submission, my lord. Corporate, my lord. So, from Koyaguchi to Kopateri. My lord. Montaz.
Mustaf.
Yes, Mustaf. Mustaf was at that time, my lord, Montaz was 50 and he was 25. 1970. 1997, his age
45.
45. My lord,
7 years.
that at the very beginning, my lord, if it is properly scrutinized, my lord, name discrepancy and the age discrepancies, my lord, it will be very difficult because in every voter list that has happened. My lord, that is why, my lord, there is no doubt about it, subject to correction by your lordship, that Jabbar Ali is son of Montaz and Mustaf is wrongly written. And that have I explained in my written statement, my lord, elaborately, that this has happened. From written statement, I can show before your lordship that actually I have explained that their names are written like this and that. So, my lord, what is the point? Point is this: Jabbar Ali is son of Montaz, and Montaz sometimes written as Mustaf. My lord. Yes, my lord. The written statement, my lord, your lordship, it will start from page 29. Sorry, my lord. Regarding the name discrepancies, my lord. Yes, my lord. The second party is a bona fide citizen of India by birth and has got sufficient documentary evidence to prove her Indian citizenship. The second party was born about 15 years ago at Kapahattari. Malo. 8. That the second party's parents' names have been appeared in the voter list of 1970 along with her elder brother Jabbar at village Kapahattari in Didan district Kamrup under so-and-so. But in the said voter list, second party's grandfather's name wrongly recorded as Bhajan instead of Bajon Ali against her father's name, and wherein second party's mother's name has also been wrongly recorded as Jamila Nessa. Jamila Nessa instead of Joymon Nessa. Father's name has also been wrongly recorded as Mustafa instead of Montaz Ali against the name of mother and elder brother of Jabbar Ali. Clearly explain. Clearly explain. So, your lordship, in my writ petition also, my shifting is elaborated. Your lordship can go to para 2. Para 2 of my writ petition. Well, written it. And pleadings is all right, well, that also. That also, the same I have stated in my writ petition also.
Yes.
Well,
Your Lordship, page 16, 1970 voter list, Lordship, if Jabbar Ali is very much alive, Lordship, during the time of deposition, Lordship, then why his name is not appeared till 1997, Lordship? He must be there, Lordship. But after 1970, there is, up to 1997, there is no existence found in respect of Jabbar Ali, Lordship. And there are place discrepancy, age discrepancy, everything, name discrepancy. Lordship has already pointed out discrepancy in respect of age and name, Lordship. So, Lordship, it is their document, Lordship. They have to prove it, Lordship. They rely on the document. In this respect, discrepancy of voter list, Lordship. Our High Court has said in Basiran Bibi's case, 2018 1 GLT 372. Para 30. 1 GLT 372. Paragraph 30. Yes, Lordship. Reliance placed in the case of Abdul Matali alias Mataleb Muhammad Supra can be of no assistance to the petitioner in as much as it has already been clarified by this court in previous decision that the said decision did not lay down any law and was the decision confined to the fact and circumstances of the case. Regarding discrepancies in the voters list, which the petitioner contended were not her creation being entered into by the officials of Election Commission and therefore should not be used adversely against the petitioner. Such contention is without any substance. The voters list were adduced as evidence by the petitioner herself to prove her case that she was not a foreigner but a citizen of India. Petitioner cannot insist that only that portions of the voters list which are in her favor should be accepted and those portions going against her should be overlooked. This is not how a document put forward as a piece of evidence should be examined. The document has to be appreciated as a whole. Lordship, if journalist evidence goes, Lordship, these are oral evidence, Lordship, and there are so many settled laws in respect of oral evidence that oral evidence without supporting documentary evidence has no value, Lordship. Then, Lordship, Tukurali's evidence is there, Lordship, here also. Tukurali's evidence was not taken into consideration. No discussion. No. No. President, and then with the evidence of DW1 petitioner and their brother of DW. That point is clear, Lordship, that has to be discussed, Lordship.
Page 44 of my writ petition.
I was born in village Kopahartari, but I do not know the date of birth. That is yes, Lordship. We are four brothers. Four brothers and one sister. year 1989. Turn on both the parents and die. Otherwise, Lordship, this will not prejudice to the petitioner. Yes, Lordship.
Let me something. Well,
Lordship, apart from that, Lordship, these are oral statement, Lordship. An oral statement without supporting documentary evidence is not enough, Lordship. Already laws are settled in respect of this, Lordship. Even it should be discussed, but Lordship, even if it is not discussed, Lordship, discussing this evidence by no way prejudice to petitioner, Lordship, proceeding, Lordship. Apart from that, Lordship, if we see the link document, Lordship, link documents are not proof, Lordship, at all. And where in Gaon Panchat certificate, his date of marriage was 2/3/1983, where the WS Lordship in place. Where she has stated that Lordship in the year of 1981, she got married, Lordship. Somewhere I have found Lordship. Para 12, the second party has casted her vote for the first time in the year of 1989 after her marriage at village Taluki along with her husband, and her husband's first wife Basiran Nesa died under 40, let's see, house number 7. Apart from that, Lordship, my humble submission is that, Lordship, Gaubra did not come and depose before the tribunal, Lordship. These are not proved at all, Lordship. So, this evidence may not, these documents, Lordship, may not consider these documents. Yes, Lordship. Otherwise, if Gaubra certificate goes, Gaon Panchat certificate goes, Lordship, there is nothing to link with our projected parents, Lordship. If oral evidence goes, Lordship. No. Oral evidence without supporting documentary evidence is not enough, Lordship. These are settled laws.
my lord, evidence of Shukur, my lord, DW3, it is with Jabbar similar, my lord. And thing is this, my lord, he said that Jabbar is my brother. Not only that, Proceedi is his sister, Jabbar is also his brother. And your lordship would be pleased to, from TCR, my lord, that Jabbar's name appeared in voter list of 1997 at page 43 of the TCR, my lord. House number 173, serial number 958. Yes, my lord. And thing is this, my lord, his father's name is also shown as Montas. So
there is no doubt that they belong to same family. And another voter list of my lord 2016. Here also his father's name is shown as Muntaz Ali. So my lord, there is no doubt regarding this family. My lord, brothers sitting. My lord. And Jabbar is not the proceeding, but my humble submission before your lordship is this, that if Jabbar say, I am his sister, if Shukur say, I am his sister. Now, thing is this, my lord, I belong to same family. None of the petitioners, none of them is proceeded with. Now, my humble submission before your lordship, why I am proceeded? What is the circumstances? Why not Jabbar is doubted? Why Shukur is not doubted? I am doubted because my name is not with parents because I entered into early marriage at the age of 17 or 16 like this. And I shifted with my husband to husband's family. With husband's, my name is there, my lord. So there is a dealing, my lord. My lord.
As part of his lordship, she got married on 1983, but as per her evidence, lordship, at page 21, lordship, page 35, lordship of the petition. I was married in 1981 with Yasin Ali, son of Mahmud Ali.
My lord, 81 and 83, illiterate lady, my lord, this maybe. What my learned friend is submitting, my lord, I am not opposing. My only thing is this, my lord. Whether the evidence of PW3 will be sidetracked in deciding the case. And that also, my lord, regarding PW2, DW2 also, my lord, only one line. Only one line has been said. That I have referred to your lordship, I am not repeating. Only one line has been said that this evidence is not trustworthy. How it can be, my lord? That's all, my lord. Much obliged. My lord.